Mr. Shivji, Miss Martin, are all present and correct on both sides?
Yes, on the claimant side.
Good morning, Your Honour. Yes, we are.
Very good. Would the associate please like to read the usual form of words?
Thank you, Your Honour. Good morning, all. This hearing is in the matter of CFI 009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Holman Fenwick Willen, lead counsel is Mr. Sharaf Shivsi KC. The defendants are represented by Jones Day, and lead counsel is Mrs. Heather Martin. Thank you, Your Honour.
Yes.
Good morning, my lord. We've prepared some documents which I hope will be helpful for today's case management conference. There is an agenda that we have prepared, which your lordship will find at page 1809.
Yes.
Of the bundle. That's our agenda, but there's no one's put forward a rival agenda, and ultimately we want to get through the materials in a logical order. So that's our suggestion as to how we deal with it. And then, my lord, separate from that, we have put together a draft case management order which sets out in one composite document the parties' rival positions, and that's at page 1779. And that version, obviously, to some extent, these things are a rolling draft as and when points are raised in correspondence and then also resolved. But that version is a version from Friday morning at 9:30 a.m. And that was with skeleton argument due at midday. And so, to be fair to my learned friends, they wouldn't have had long with that particular draft when they filed their skeleton argument, and they just wanted me to flag that to you. And of course I have.
Could I also interject that I believe that we did come to agreement on a couple of the points that we sent through to HFW, and they had sent us back a draft which we agreed to. This was all very shortly before the hearing, so that information might not have made it to Mr. Shivji.
I think some of it has. I'm grateful to my learned friend for that. If I may, as I work through my agenda, I hope to flag those points where I think they've fallen away. So I'll do that as we go, if I may, my lord.
It is found at page 2564, if it is helpful, the new draft.
I'm afraid not in my bundle, so I might stick with 1779 for the time being, and I'll pick those points up as we go, please.
2564, did you say, Mrs. Martin?
Correct.
Thank you. Okay, well, I've got a note of both. Thank you.
I'm grateful, my lord.
Yeah.
So my lord, there are a few points I wanted to make about just the overall approach before we dive into the detail. There's some time spent in my learned friend's skeleton argument suggesting that we are envisaging some very substantial worldwide disclosure exercise for this case, which will involve crawling over all aspects of the defendant's business, even in areas not obviously relevant. And I just want to reassure your lordship that, of course, that's not what we are trying to do here. We recognise that disclosure must be reasonable and proportionate, albeit bearing in mind that this is a fraud case where the alleged fraud is said to have taken place covertly. And what we're trying to do is craft sensible and targeted search so that the relevant material can be ascertained. And the foundation of that exercise is that there is a strong need for openness and transparency from the defendants as to what they have and how they organise their business, so that those searches can be focused and targeted. And of course, the greater level of openness from the defendants, the easier it will be to craft the exercise. Now, regrettably, without throwing stones too early into the hearing, thus far we have just not seen that level of openness and cooperation that would be needed in a case, any case like this. And as we say, the court usually expects. And in the run-up to this CMC, we wrote ahead of the deadline for EDQs and disclosure questionnaires. We wrote again afterwards, and essentially our correspondence was ignored on all of the key substantive issues until we received a very long letter last night, Sunday evening, It's 19 pages. We also received over the course of Sunday, I think, some 10 authorities and a further exhibit. It does seem that the defendants really are trying to treat this exercise like they have the previous ones, that it's a war of attrition where you give away nothing, and then at the last minute there is warfare. And I say that simply because, for our part, we don't find that helpful, and it actually slows down the process and makes it a bit more expensive. My Lord, with that introduction swept away, I was going to address you on agenda item 1, which are the items where further information is sought in relation to disclosure. And what I was proposing to do is take you through each of the items under item 1. There are 5 sub-items. And then, subject to your lordship's view, it might be sensible for my learned friend to then respond on those issues, and for me then to reply, so that you've heard what we said on that topic before we then move to the next topic.
Yes.
So, my Lord, the first topic I wanted to address you on was the preservation and destruction of the defendant's documents. This is a point that we pursued in pre-CMC correspondence and raised in our letter of the 21st of May 2024. And that was a letter, in fact, I showed to your lordship at the last hearing when we were looking at the second removal application. It's a point that really hasn't gained any traction with the defence at all until their letter of last night. And even then, their letter of last night, we say, was unsatisfactory. And I'm going to show you that, but I just want to explain the context of it. As regard this aspect of disclosure, there are 2 relevant duties that I want to draw to your attention. The first is that a party is under an obligation to preserve documents, at least from the point that litigation is contemplated. And that obligation includes putting in place document preservation measures.
Yeah.
So that's the first duty. The second duty is that a party's solicitor is under a professional obligation to ensure that the client understands that duty to preserve, and the solicitors must take positive steps to ensure compliance. Now, those duties are found at various places in the CPR.
This is all familiar territory, Mr. Shivji.
I know, my lord. I wouldn't mind, if I may, just showing you, though, the sort of essentially I know your lordship will be very familiar with this, but if I may, I'll just show you the mechanics of what parties are expected to do. I'll do it quickly, because then we'll just examine what the defendants have done. So, my lord, if we look at the sort of clearest articulation is actually in the current practice direction 57 AD of the CPR, which is adopted into the RDC by rule 2.10 of the RDC. And that's in your bundle at 2330.
Yeah.
And the duties, the client duty that I referenced is at 3.1 sub 1, and the solicitor's duty is at 3.2 sub 1. And then if we go on to paragraph 4, paragraph 4 actually just explains mechanically what parties are expected to do when it comes to document preservation. And if your lordship could kindly read 4.1 to 4.3.
Yeah.
So in essence, a client, as soon as litigation is in reasonable contemplation, a client is under an obligation to send out preservation notices, and that goes to both employees and former employees. And then under 4.4, this is the solicitor's duty, and the solicitors effectively are required to make sure that their client has taken those steps, and indeed to obtain written confirmation from the client that they have. And in separately, my lord, if one now turns to 2293, this is an extract from Matthews and Malik on disclosure. And your lordship will be very familiar with all of this, but if your lordship could read paragraph 1805, please.
Yeah.
And so my lord, the trigger point for all of this is when litigation is contemplated. My learned friend's position is that litigation was in reasonable contemplation from February 2022, when the defendants received a pre-action letter. We say actually on their own evidence, it looks like they were in contemplation of litigation much earlier. And I'll just take you to Mr. Divenish's evidence on that, which is at 1640. And if your lordship could read paragraph 36, please.
I think I've got the wrong page.
Sorry, it's 1640.
Sorry, I put in the wrong number. Yeah.
So Mr. Devenish's evidence here is that the individual defendants were aware as long as 2016 of the risk of litigation, in particular in relation to our insolvent estate. Of course, the individual defendants, two of them are very senior officials at the fourth defendant, and one of them is a director of the fifth defendant. So insofar as they have knowledge of the risk of litigation, that was obvious. That would obviously be knowledge that would also flow to the fourth and fifth defendants. So we say there's a perfectly sensible analysis that, in fact, they were under threat of litigation from 2016. Now, just in terms of the chronology, in February 2022 was the pre-action letter. In April 2022, the defendants received the draft predictive claim. They commenced their own proceedings in Switzerland in January 2023 and became aware of our proceedings here shortly after. They had their jurisdiction challenges dismissed by your lordship in September and November 2023. And yet the fourth defendant only sent out a partial document preservation notice in January 2024, which on their own case was nearly 2 years late. And as for the fifth defendant, it only sent out a partial documentation preservation notice in February 2023, which again on their own case is a year late. So on its face, my lord, both the fourth and fifth defendants were in significant breach of the client duty, which required them to preserve documents from the time that they were in contemplation of litigation. And no adequate explanation has been given for these breaches, or indeed actually what the current state of play is in relation to the actual documents. Can I just pick you up on their failure to provide a proper explanation for the breaches? This is their letter from last night, 2348.
Could we please go to the top of the section where we start addressing this?
Well, actually, I'd like to deal with this in pieces, my lord. So I will take your lordship to the other parts, but at the moment I'm just dealing with the explanation, and then I'm going to deal with actually what the current state of play is in relation to the documents. So just in relation to the explanation, it's the second paragraph. and where they say the few custodians who remain associated with the fourth and fifth defendants who are in possession of documents of any likely relevance are well aware of their preservation duties. For reasons apparent only to prior counsel, they did not counsel our clients to issue a formal document retention memorandum in early 2022. I just want to pause there for a moment. So the explanation they seem to be offering is that they were not advised by their previous advisors to issue preservation notices, and that their previous advisors not identified, but it's probably Clifford Chance. Your Lordship will remember they were also represented by Herbert Smith, but we think it's probably Clifford Chance. And when they say rather delphically, for reasons apparent only to prior counsel, what they seem to be recognising there is that there is, of course, a solicitor duty, and they can't explain why that solicitor didn't discharge that duty. But what this letter omits to mention is that Jones Day themselves were acting for the fourth defendant from around August 2022. And we know that from the engagement letters that they have disclosed in these proceedings as part of the jurisdiction challenge, which make it clear that they were acting for the fourth defendant from about a year before they started acting for the individual defendants. And so that would take you to August 2022. And there's rightly no suggestion in this letter that Jones Day did.
Can you please take us to a document that confirms those dates? Because I don't recall August being correct. I may have.
Yeah, my junior will tell me where the engagement letter's gone into the bundle. It's at 2442 of the bundle. Sorry, my lord, can I just get up my version? Because so this is the Jones Day engagement letter for Mr. Sassoon of August 2023. And then if you go to the second page, it's the first sentence. As explained above, Jones Day has represented Safra Sarasin in this matter for approximately 1 year. So I mean, my learned friend might quibble with August 2022. I mean, it's her client's, it's her firm's letter, but that's where I got the date from, August 2022. So for around approximately 1 year before, they had been acting for the fourth defendant in this matter. And of course, I make no criticism of Jones Day, and there's no suggestion that they did not comply with the solicitor's duty. And of course, there's every expectation that they would have. I mean, they rightly don't suggest they didn't. And it's routine for firms to give that sort of advice. But putting aside what Jones Day says, so we say that BGSS would have full well known the position from Jones Day being on the record. And so it's no answer that they weren't given this advice by Clifford Chance. But in any event, both the fourth and fifth defendants are regulated financial institutions, and they will be very familiar with the concept of document preservation. The way that my learned friend put it at the last hearing was that her clients were very familiar with disclosure processes, and she captured the point excellently when she said that they had attended this particular rodeo before. And that's exactly what you would expect as experienced financial institutions. They would know the rules of the game. And finally, I'll come to this later, but it now appears that Mr. Astruct is actually the person giving instructions to Jones Day in relation to this litigation for the fourth defendant. He's the general counsel of the fourth defendant. And we say, is it realistic that the general counsel of a major Swiss bank has never encountered the concept of a litigation hold or document presentation? And we just say it's unreal to think that someone like Mr. Astruct wouldn't know about that. So, in fact, properly analysed, there is no satisfactory explanation as to why these document holds were put in place so late. And I make it clear that I'm making no criticism of Jones Day. On the contrary, I think the court should proceed on the basis that they have properly discharged their duty, and the question mark hangs entirely over their client as to why they didn't take the proper steps required under the rules. Now, my lord, we, in terms of actually what was then put in place late, the fourth defendant sent out a document preservation notice in January 14. The fifth defendant seems to have done that a year earlier in February 2023. Sorry, I said 13, I meant 2024. So the fourth defendant sent out a notice in January 2024. The fifth defendant sent out a notice, I think, in February 2023. All of those were materially late. We've asked for copies of those preservation notices and the retention of policies that apply, but they have still not been given to us, and there's no explanation as to why we can't see them. But the reason we want to see them is because it then drives the question of whether actually this matters, whether there is a risk. I'm not saying through necessarily deliberate destruction, but whether there is a risk even through routine or destruction, that certain types of data has been lost or repositories not renewed. Now, in these circumstances, one would expect a witness statement from the defendant supported by a statement of truth, apologising for their breach of duty and giving a frank explanation to the court as to the state of play in terms of document presentation. And that isn't what's happened. Instead, we've had two letters on the point. The first was very brief, and then we received the longer one last night. The letter from last night seeks to suggest that there has been no deletion of data relevant to this litigation since February 2022, but a close analysis of that letter and the previous letter reveals a number of inconsistencies and holes. And I wanted to raise 4 examples. And as we go through those examples, I'll take you to the passages that my learned friend wanted you to see from the letter of last night. So the first example I wanted to take was BJSS-AM's position on client data. And if you go to page 1594, please. And this is talking about the document retention policies of fourth and fifth defendants, but just looking at the fifth defendant for a moment, it's the last sentence of the second substantive paragraph. And it says there, in general, client-related information of both BGSS, we'll come back to BGSS, and JSS-MEs, the fourth and fifth defendants, is currently deleted only after the client relationship has been closed with a zero balance for more than the regulatory period. And then it explains that the regulatory period is different for those institutions, 10 years for BJSS and 6 years for the fifth defendant. Now, the words is currently deleted do seem to indicate this is an active policy. So that, and that's often the way that these retention policies work. Your Lordship will know from GDPR, I suspect, that actually these days one can't generally hold data unless you've got a good reason for holding it. So you just can't keep data ad infinitum. And as a result, as a regulated institution, you do have to manage your historic data. And so where your policy says you should only keep things for a certain period of time, generally speaking, you tend to delete it after that period of time because you've no longer got a legitimate reason to hold it. And that's especially so when it comes to sensitive data like client data. So what this seems to be saying is the policy is the currently applied policy is for deletion after the expiry of the regulatory period, and for the fifth defendant that is 6 years. And so what that means is for a client who was poached by the fifth defendant from us, sorry, poached is rather provocative, who was adopted by the fifth defendant from us in 2013. And then left, let's say, after 3 years, well, it's delayed. It would have left them by 2016. Its data would have been deleted by the end of 2022. And that would have been before any preservation notice was issued. And since the preservation notice was only issued in 2023 for the fifth defendant, that means that the data of any client who had left before 2017 would have been deleted, even if they were relevant clients for this litigation. Now, my lord, so that seems to be on an analysis of what they have said about the current application of their retention policy, how it works, and that data seems likely to have been lost. If you now look at what my learned friend wanted you to see from her letter of last night, that's at 2347. And it appears under the heading document retention. And she says there, your letter appears to allude two separate matters. One, our client's document retention policies. Two, legal holds put in place at the time at which litigation was contemplated. Your skeleton argument raises a third matter, a rank assumption that has been data spoliation at our clients since they became aware of likely legal proceedings. Taking three first, and to prevent you wasting valuable CMC time erasing on an imagined spoliation issue, allow us to respond with crystal clarity. Neither our clients nor we, following hours of diligence, have reason to believe that there has been a deletion of any data relevant to these proceedings since them becoming in reasonable contemplation of legal proceedings on the 1st of February 22, the date on which your clients issued their letters before action. We reiterate that no systemic purges have taken place. So just pausing there, my lord. First of all, they talk about hours of diligence. That's a phrase that sounds impressive, but actually when one picks at it, a few hours of diligence really wouldn't give one much comfort. And really what they ought to have done here is set out properly the investigations that they have taken and through whom. Was this something that Jones Day pursued, which they ought to have because it's a professional obligation that they have, or was it Mr. Astruct? And what verification work was carried out? And if as seems likely, we say Mr. Astruct is the source of information from this, then that's very unsatisfactory. And in any event, if it's only a few hours of work, then that can be only very little comfort to your lordship. But in any event, how does all of this sit with their previous letter? Because their previous letter made it clear that the current policy currently applied was a 6-year retention policy. And that would imply that historic data has been deleted. And in fact, in this letter, in this section, the whole of this section, there is no mention at all of the fifth defendant's client data. So when they come to talk about client data, if we pick this up actually at the next page at 2348 at the bottom at B, and if your lordship could kindly read that.
Yeah.
So there's no mention there of the fifth defendant's position. In fact, if one read that and nothing else, you would be under the impression that the applicable period is 10 years. And while they say that's the period for BGSS, that isn't the period for the fifth defendant. So this letter just ignores the position of the fifth defendant in the client data. And that's why we say that the assertions that it's all fine and there's nothing to worry about really are just not satisfactory given where we find ourselves. But my lord, can I just pick up on the fourth defendant's position? There has actually just been a subtle change of position between the two letters on its retention policy, because it was said previously that it was a 10-year period, and I think 10 years from the client having a zero balance and client account closure. But here they put it slightly different, and they say at the last line of 2348, they say that the time actually runs from the end of the calendar year plus 10 years afterwards when the client is no longer a client of BGSS. So they say that whenever you closed it in the year, you then get the whole of that year plus another 10 years. And that's important, again, because of the timing of this notice. The notice was January 2024. And we need to know, actually, the relevant period goes back to sort of 2013, 2014. So it actually matters a great deal as to whether you've lost client data from 2013 or not. And again, they say nothing about that. The example they give at B is an example of a client that left in 2014. But what about a client who was acquired early in the process in 2013? and then perhaps left shortly after. And if that happened, even on this analysis, before the end of the calendar year for 2013, that data would have been deleted at the end of 2023 before the retention preservation notice in January 24. So again, this is just very unsatisfactory position. And again, the sort of thing that should be covered off properly in evidence. That was my second example. Can I give you my third example at 2348? And if your lordship could read A, please, on that page.
Yeah.
So what that seems to, so they say that they don't systemically purge documents, but it isn't actually clear what they're saying about all of their historical data. Are they saying that they keep emails and non-client data ad infinitum? And if that is what they're saying, that would be actually fairly astonishing for a financial institution. The amount of data would be huge over tens of years of data collection. And electronic data, of course, is a fairly modern advent, but really since the 1990s, there have been very big volumes of electronic data. So it just seems unreal that they would have all of their emails going back for such a long period. And again, actually, my lord, we don't need to turn it up, but when we looked at that last letter, the 30th of May letter, it talked about BGSS's document retention policy being 10 years. And that letter said that it was a comprehensive policy. Again, one would actually assume that in line with that policy, it may well be that after 10 years, they are letting email data and other data go, whether that's actually routinely deleting or simply just not renewing archives or not upgrading systems. And that really is, I suppose, the next point is that all financial institutions are in a constant state of flux in terms of updating systems, buying new systems, transitioning data from one to the other. And so again, it's just unreal that their entire body of data for all time would just be kept and rolled forward without anyone checking whether they still needed to keep it. Now, they also say in this letter at the top of 2348 that most of the custodians who were involved in this matter have since left. And sorry, I'll just get that 23. Yeah, that's the second paragraph. The few custodians who remain associated with the fourth and fifth defendants. So as we understand it, what they're saying is that most of them have left. And again, the question is, are they really saying that they've kept all of this custodian data for all of these people who've left? And we need to know. And if they haven't, if they failed to preserve that data, that again is a relevant factor. And I'll come back to the relevance of it in these proceedings. Now, notwithstanding the fact they issued a preservation notice in January 2024 for BGSS, there was still a data deletion event. The risk of a data deletion in March 2024. And if your lordship goes to 1594, they say in the third paragraph, right at the bottom, on the 7th of March 2024, BGSS prevented the destruction of documents and information related to the other BSA entities by agreeing with Alpen to instruct the vendor to maintain them for another 3 years. And this really links to what I was saying earlier, is that if you hold data, you may not have systemic purges of your data from time to time. You may not have deletion exercises. But if, for example, you've got a vendor holding data for you, you might simply not choose to renew it in relation to historic data. And what seems to have happened here in March 2024 is that they required some proactive action on their part to prevent a deletion event taking place. And that was notwithstanding the fact that they had issued a preservation notice in January 2024. So again, we just say this is an illustration that preservation requires active management, and that whatever that preservation notice was in January 2024 that we've not seen, it obviously wasn't comprehensive enough to stop the deletion with this vendor in March 24, which is why it required further action. And that's one of the reasons why we want to see all these notices. So my lord, pulling, oh, sorry, and there was one other deletion event as well, 2349. This is for the 5th defendant. And at the bottom of 2349, last paragraph, they say, in relation to the data retention incident affecting the 5th defendant's phone recordings in 2017, there was an incident involving the Dubai server which resulted in copies of recorded telephone calls from March 2014 to October 2017 being erased into Dubai, but remaining stored via a backup server in Switzerland instead of being stored locally. And they say, we understand no data was lost as a result of this, but the sole storage location is now Switzerland. So again, there was a data deletion event in Dubai in 2017. If actually, in accordance with Mr. Devenish's evidence, had been in contemplation litigation since 2016 and put a notice out at that point, the preservation notice would have been in place before that incident. They say that no data was lost because it's in Switzerland, but what they haven't explained is whether they say that there are any legal restrictions as a matter of Swiss law which now prevent that data from being accessed. And of course, if there is, then that would be a point of a prejudice that flows from the fact that no preservation notice was put in place at the right time. So my lord, just putting all of that together, 4th and 5th defendants are in breach of their document preservation duty by a number of years. On the terms that we have been told of their document retention policies, one would have expected relevant data to have been deleted. They have offered insufficient comfort to the court that no data is being lost. A letter apparently on instructions from Mr. Astrup is just not satisfactory in those circumstances. It's actually unclear what investigations have been conducted and their account is inconsistent. And in any event, issues of this nature ought to be covered in a witness statement supported by a statement of truth. Now, why does all of this matter? It's because the court and the claimants will need to have visibility of what has been preserved and what has been lost for 3 reasons. First, my lord, if certain categories of data have been lost, for example, emails, then that might well make it more likely that the court will require other areas to be searched, for example, like telephone calls. So the loss of certain relevant data might cause your lordship to craft the disclosure exercise in a different direction. That's the first point. The second point is that your lordship will need to know at trial whether there are missing parts of the record or whether searches have been conducted and no responsive documents have been identified. And that may be really material in a fraud case where your lordship is trying to draw inferences as to what's happened from the known facts. And there's a very significant difference between documents being missing and there being a complete record, but no event having occurred on the face of the record. And so it may well lead to a very different outcome in your lordship's fact-finding exercise. And then thirdly, the circumstances of the document destruction might lead to the court to taking action. And in particular, the court will want to know if the document destruction was deliberate or reckless, and that might lead to inferences or even in an extreme case, striking out. So my lord, the order that we seek on this is essentially a witness statement. It's something they should have provided voluntarily without us having to ask for it. In our order, sorry, my lord, I'll see if I can work from the latest version. If I don't actually. So if going to my order at 1779, and it's under the production of documents, and we are requiring the defendants to file and serve evidence, and it's items B to E, so 4B to 4E.
And who is going to swear this affidavit or witness statement?
Well, we would expect someone on their client side, on the fourth and fifth defendant's client side, because it is a factual inquiry, and I mean, I'm going to come back to this when we look at Mr. Astruck's involvement in this litigation, but plainly as a individual defendant to this action, where he is personally being accused of fraud, it would not be appropriate for he to be the right person to tell your lordship the factual inquiries that the fourth and fifth defendants have carried out in discharge of their disclosure obligations. And as we understand it, ordinarily what would happen in this sort of situation where you've got an officer accused of fraud is that the board would appoint a special committee of the board to deal with this litigation that was ring-fenced from the individuals who were impugned in this litigation, and that they would essentially be calling the shots. I mean, my understanding is that that's standard procedure for a board to do that. And in circumstances where the head of legal is impugned, you might well get someone else. I mean, it's obviously that makes it more difficult, but you'll get someone else senior from the organisation who's not impugned to do that. And we discussed this at the last hearing. It's not that you can't speak to the person who's impugned in order to get information from them, but actually on something like this, there's no reason why Mr. Astruck will be the sole font of all knowledge on the fourth and fifth defendants' document retention procedures. In fact, the likelihood is that he's operating at a higher level than all of this, and there'll be administrators and other officers within the organisation, data officers, who will know this inside out. So it's a matter of finding the right people in the organisation who can give evidence to your lordship on oath as to actually what they've done, and give your lordship some reassurance and information as to what's happened. Now, my lord, sorry, I just want. Sorry.
Your paragraph 4, just to be clear what it is you're asking for. The defendants shall, pursuant to 2814, by a senior officer.
Yes.
Is that what you want to say?
Yes, that would be helpful, my lord.
By a senior officer other than a defendant.
Yes.
Other than an individual defendant.
Could I ask for that to be someone with firsthand knowledge? I mean, if the court is intending to order this, I mean, I'll address the court separately, but I don't. A senior officer is unlikely to be in firsthand knowledge of.
Well, I'm very open to suggestions, Mrs. Martin, as to who would be the appropriate person, and it may be that there would be a requirement that the statement be a joint statement for more than one person.
Yep.
So that if there's someone who knows all the nitty-gritty of what the policies are and can exhibit the policies and so on and so forth, and a senior officer who says, well, I've investigated all this to myself with my juniors, and I endorse what's being said. I'm just looking for a practical way through this, that's all.
Yeah, well, your lordship's proposal of the joint statement we think would be the appropriate way to deal with this. And you do need the reassurance of I mean, one of the challenges is when someone senior in an organisation is impugned, you do need that's why you need these different structures, so that you have the reassurance that they're not being lent on by the junior person's not being lent on by the person impugned. So my lord, that's I just wanted to make one point clear. I haven't spelt out as clearly as I probably ought to have in the order. In our letter, we made it clear that we wanted copies of their retention policy and the terms of any legal hold, and that and so that it may be that we should insert that expressly into the order to make it clear that that will need to be attached to the statement.
Yeah.
I'm grateful, and my lord, I don't need to dwell on this too much, but these are the sorts of orders that the court has the power to make and does routinely make. Your lordship will have a view on that. But in the authorities bundle, I provided the Glaxo case, and that was a sort of very similar fact pattern. It was a very complex disclosure exercise there. There had been a deletion of a system that the parties all called a database, but the judge didn't think it was a database. And one of the party that was responsible for the deletion said, look, what can we do? The data's gone. That's the end. We've told you that's the end of the matter. And the judge said, no, we really do need to set this out. This is important. It's might be relevant for later. Actually, I'll just show you the sort of punchline of that judgment, which is at 2033. It's a decision of Chief Master Marsh.
2033.
2033. And if your law, the punch line is at 12, where in response to this submission, well, you know what's happened, so you don't need any more information. And at para 12, the judge explains that it is important, nonetheless, to get an order with the information being provided.
Yes.
So, my lord, that was my 1.1. That brings me very neatly into 1.2, which are these points about the integrity of the disclosure exercise. Now,
I actually think it would be helpful if I could respond to some of these points before you go into 1.2.
Well, actually, I think subject to your lordship, I see these as interconnected. So I was going to finish.
Well, wait a second. First of all, Mrs. Martin, are you objecting? Are you contesting the need for a witness statement?
We're happy to provide a witness statement, but I think that we should all be clear what the facts are before we go through what the contours of whatever it is Mr. Sheepji is about to say says.
Well, if we're going to talk contours, then it probably does make sense for Mr. Shivji to make his next point and you to revert on all of it in one go.
Certainly.
I'm grateful. So, my lord, what item 1.2 of the agenda was whether the individual defendant should be decision makers or givers of instructions to Jones Day in relation to the defendant's disclosure. And we've been
through this ground, haven't we, Mr. Shivji?
I have. This is a point of real significance for us, because we do. Your lordship said at the last hearing that disclosure in a case like this is critical, and we also share that view, and we do have real worries about the integrity of the process. And I sort of won't want to labour the point. I just want to give you a few examples as to how this could really matter and why we say this is something that requires the court's intervention. And I think the suggestion from my learned friends is that this is all some tactical wheeze, just to put them under pressure. But it's not that. It's because the court and the claimants need to have reassurance that this exercise has been done properly. And the way that it's described in Matthews and Malik, we don't need to turn it up, but the way it's described is that the disclosure process must have integrity. And that's at 2295 of the bundle. And the way that it has integrity is that it is the solicitors who have essentially heavy involvement in the exercise. And it is not for the client to be making decisions on essentially relevance or which types of documents are going to be searched. That is a matter for the solicitors to do, having essentially captured the relevant universe of documents. Now, I raised this at the last hearing, that we had concerns about who was giving instructions to Jones Day. And we also wrote a letter on that. And the response that we got essentially was that it was suggested that I had withdrawn this point at the last hearing, which I don't recall doing, and that in any event, the identity of the person giving them instructions was privileged. Now, we went back to point out that, first of all, this point was being maintained, and secondly, that the person giving instructions was not privileged. And we referred to the Lauralee case, which makes that clear, and that's Court of Appeal authority. The letter that we got last night on this appeared to reveal that it was Mr. Astruct who was actually giving Jones Day instructions in relation to this matter. And that, frankly, might explain some of the applications that we've seen in recent months and years on this case. But that is a very unsatisfactory position when it comes to look at disclosure, because the court is relying on the person giving instructions to give accurate information as to what exists. And also that when points are being run about the scope of the disclosure exercise, points like proportionality, that those points are being run for proper reasons, because there is a legitimate concern about the point, not because they're being not in order to avoid someone looking in an area where there may be problems.
Mr. Astruc is general counsel, right?
He is, that's right.
And what's his legal qualification?
I don't know. He's not English law qualified. I know that.
No, I assumed.
I believe it's French, but can I double check that?
Yeah, thank you.
But my lord, on that, it's. I mean, there is a. I mean, culturally, there is a world of difference between different jurisdictions on this, and I mean, Mr. Astruc is accused of fraud. There's no beating around the. One's normally very reluctant to say anything disparaging about a fellow lawyer, but I must remind myself that this is a case where he's a defendant, not a professional acting in a capacity, and he's accused of a serious fraud, which was a conspiracy, and he has an obvious conflict of interest when it comes to leading the fourth defendant's and fifth defendant's disclosure exercise, just to give you an example of how this can have a real impact in this litigation. So if you go to 478, my lord. The bundle. And this is, your lordship ordered on the 19th of April that the parties provide material on their hard copy repositories and searches. And if you go to the fourth defendant on the next page, it said there very simply, the fourth defendant does not have any hard copy documents pertaining to BSA that are not already in electronic format. As such, the fourth defendant does not intend to undertake any separate searches of hard copy repositories. Now, you can tell from the second sentence that that they can't have conducted any searches yet. And so the first sentence must be based on instructions. They're not saying we've already conducted a search, even a scoping exercise, and that actually, having looked at the indexes of what's kept, there aren't going to be any documents relevant to BSA. They seem to be saying on instructions that there are not any hard copy documents relating to BSA.
Well, of course, that might be the case if they'd reduced all hard copy documents into electronic format.
That may be the case. That may be an explanation, but that's not offered here. And actually, that is the sort of explanation you would give. You would say, I mean, that's a critical piece of information to say, actually, hard copy has become electronic, and we're going to search the electronics. But that's not.
The first sentence may or may not say that.
I see that. But I mean, this is a really good example of something if that's being said on instructions, and those instructions come from Mr. Astruc, that is wholly unsatisfactory as an answer for defining the scope of the fourth defendant's searches. And we know, and we'll look at this later, we know that the fourth defendant's board considered the issue of the winding up of BSA. That was considered at board level. The board, I mean, this is a decade ago. At that stage, boards were not fully electronic. And one would expect there to be some hard copy documents. I mean, just to give you a sort of flavour for it, my client, the claimant, the first claimant, has 212 boxes of hard copy documents records from that period. So one would expect ordinarily for materials around that time to have been generating some hard copy material, and so one does. It is surprising that there is no hard copy documents. As you said, the explanation might be that they went through a digitalization process, in which case they'd need to say that in evidence, and they ought to have explained that. But this is exactly the sort of thing Mr. Astruc ought not to be calling the shots on. Your lordship will want to be sure that where we're getting information about the fourth defendant's record keeping, repositories, and proportionality, that's coming from someone wholly independent of the allegations in this litigation. And the way your lordship put it at the last hearing was that if, in the absence of comfort from the defendants, that we might need to get into a world where they need to provide witness statements, and we say, unfortunately, that is what has happened. I should say it's a point which ought to operate for Jones Day's protection, so it's not something that's necessarily bad news for them either. We say that if you go to the draft order, this is 1780. and this is 4A. So we were expecting them to cover this off as part of their evidence as well.
Sorry, could you just give us the page reference again, please?
Yes, 1780, para 4A.
Well, surely what's needed is a witness statement that says who in fact is taking responsibility for that. I mean, what I will want to know is who is the individual who can answer to it should there be a need for cross-examination, and indeed the involvement of Jones Day in it as solicitors. Just to make sure that the exercise is done properly. So we need both the integrity preserved from the point of view of the bank itself and clear statements as to the involvement and advice and direction that's being given by Jones Day, whether it be Mr. Devonish or Mrs. Martin or whoever else is responsible for it. And so we can be confident that the job's being done properly. So that may need a bit of rephrasing, I think.
There's considerable force in what your lordship says. That I'd adopt that. It's wonderful practicing in an international jurisdiction with lawyers from lots of different parts of the world, but the particular role of a solicitor in an English standard liquidation exercise is something that is more familiar to common law qualified lawyers, and it spells out very well in Matthews and Malik how, I mean, sometimes I find that actually international clients find it quite hard to get their head round the extent to which the lawyers must take control of the process rather than the client. And certainly for some of my more demanding clients who are themselves big corporations and with very experienced internal lawyers, they find it quite culturally hard to accept that the solicitor's firm on record needs to supervise the process and have a great deal of granular involvement. So, well,
if you come from a system where you only have to produce the documents that you want to produce and you rely on, the whole thing seems extremely foreign and hard to understand how it is that the court could require you to produce lots of documents you don't want to produce that are going to help the other side's case. But that's the way it is.
Yes. So my lord, I endorse what your lordship said. I think that would you're right. My order doesn't quite hit the mark on that, and we ought to have covered off in the way that you've identified.
I mean, now, my lord, at the end of the day, supposing there's a real issue about this, and that you want to make points at the end of the day that inferences to be drawn because documents haven't been produced that must have existed and so on and so forth, then it's possible that Mrs. Martin may want to produce the person who's been responsible, who could be cross-examined as to what they have done and to make sure everything has been done honestly and so on and so forth.
Yes, exactly. Well, my lord, with that may be a world that we end up in, and it would, as you say, it helps if there is a person, and it also focuses the mind, I think, in terms of the quality of the exercise. If someone knows that they have got professional responsibility within the organisation for this.
Yes.
So my lord, that's the end of my 1.2. My 1.3 actually is 1.1 and 1.2 were really points about the integrity of the exercise. Yes. 1.3 is actually about understanding in more detail how the fourth and fifth defendants work, which is slightly different in nature. So if it helps, I'm quite happy to pause there for my learned friend to address you on 1.1 and 1.2 insofar as she actually contests any of it.
Yeah, I just want to check. Yes, all right. Is that a convenient point, Mrs. Martin, for you to say what you want on these particular aspects?
Certainly. Thank you very much. The first thing I would point out is that the claimants offer these concerns against the background where they failed to disclose their repository of recorded phone calls that we know to have existed at BSA. And so I think the first question I would put back to claimants is why they didn't disclose them, if there's a spoliation issue on their end, and if so, what happened to them. And in any event, I believe that in light of the failure to disclose those, that any order directing disclosure on these points of custodianship should be reciprocal and should also apply to the claimants. So,
have you made an application for that?
We have not made an application for that. We've sussed it out in letter writing.
Well,
but we just received their draft order with these new points on Friday, and as the court is hopefully aware, there's been a lot of paper flying back and forth over the past 2 weeks, and we did come today as prepared as we can. But we would, if it's helpful for me to make an application here orally to that point, then I do so.
Yes. Mrs. Martin, you know how these things work. You know, if you want an order from the court, ordinarily you make an application and you put in evidence as to where there's been a failure.
Okay. We wanted to get a response from.
I'll wait to hear what Mr. Shivji has to say, but I've got your tit for tat point, so to speak, if I can use that expression. And I'll hear what Mr. Shivji has to say in a moment, and it may be that you'll have to pursue that either on a different occasion, or if Mr. Shivji is happy to play ball, maybe a witness statement from them will be required too. You know, I'm all in favour of saving time and making orders while we can, as opposed to unnecessary formalities. But let's see where we get to.
Thank you, Your Honor. And our apologies. The point was still in discussion in the letter writing, and so generally I like to let these things shake out before troubling the court with them. Sure. So the various guidance that Mr. Shivji pointed the court to at the beginning all talk about documents which might otherwise be deleted or destroyed. The steps are required to preserve those documents, and I think it's very helpful to kind of take a step back and take a very practical view of what the data is that the bank has. And I think of it in 3 tranches. First is the emails. There's one legacy system that's Lotus Notes, and then there is an existing system that was also a legacy system as well that is Enterprise Vault. I'm sure the court's very familiar with these issues. Those document repositories cannot be altered by individual custodians. It can be helpful to go into the individual custodians' collections instead of the vault at times, because they will have maintained the foldering system, so it can be a helpful way to triage what documents we're looking at. But to the extent there is any concern whatsoever that any emails were altered, lost, or destroyed, the bank has never run a document purge exercise on either of these systems. So as to Mr. Shivji's disbelief that they might retain these documents ad infinitum, I'm sorry to inform him he's going to have to remain in a state of disbelief. Those are the state of affairs.
And when did those systems cease to be used, or over what period were they used?
Lotus Notes was the legacy Safra system, and custodians were gradually weaned off of that and moved over into the Outlook system. The legacy Sarasin crew has always been on Outlook, but now everybody's on Outlook. So these are active databases that exist. Or I should say, I'm sorry, the Outlook database is an active database that exists. And so if we could actually take the court to page 477 of the bundle.
Yeah.
Although it's consolidated onto one page, we thought that this relayed a lot of information to the claimants, and it tells the court which custodians, which defendants' selection of custodians A, are still active, meaning still affiliated with the fourth defendant, the location of their employment, and then when and if they were on Lotus Notes versus when and if they were on Enterprise Vault.
I'm sorry, I must be on the wrong page, Mrs. Martin.
477.
Oh, sorry, I'm at 478.
So the date ranges that we put in there are from our proposed date ranges of relevancy.
Oh, right, yes, this document, yeah.
So I think it's helpful just to point out, particularly for Mr. Astruc, yes, he is still an active user. Of course, he's located in Switzerland. And because he came from the legacy Safra side of the house, he was on Lotus Notes at the time of the merger. We have this here from the time of the retention of Herbert Smith, I believe, but obviously it would predate that as well. And that his migration over into the Enterprise Vault post-dated December 2014, which, based on the particulars of claim, we have considered to be the end date of the relevant period. So we wouldn't find anything in the Enterprise Vault for him during that time period, but we would in the Lotus Notes database. And I guess just to contrast that a bit, you can see the migration becomes a little bit more obvious if you look at someone like Marcus Affolter, where you'll look and you'll see that he has both Lotus Notes and Enterprise Vault data available.
Which overlap.
Which overlap, correct.
Why would that be? Are they different? Do they cover different aspects or something?
They cover different aspects. I think part of it had to do with that if you had a client-facing role, then you got put on Enterprise Vault immediately, is what I recall the distinction being.
Right.
I think there was some incompatibility between Enterprise Vault and some other system that made it difficult for some of the more senior lawyers and others. So the migration happened later. In any event, there have been no deletion exercises run on either of these databases. So as to the second tranche of data, that is data on network drives. Now, most of the network drives, as one would expect, are pretty locked down. There's a lot of control over them, but individual custodians do have essentially a desktop that they actively use. And so where we say that there is potentially a small minority of data that might be susceptible to deletion, it would be an individual user's individual space on the network drive. But and we haven't made it this far in the exercise yet. I do understand that that might be backed up if we develop any concerns about that there has been any actual deletion. As for
what about additions?
Additions?
Yeah, I mean, I don't know what people do, how they operate, because everybody operates differently. But you know, I sometimes a lot of stuff I would print out documents and then I would make handwritten notes on them, or I might print out the document and then add on my computer notes to them. You know, there are lots of different systems where you can do that. I mean, how have you investigated those sorts of issues?
It's not my clients, and I've talk to all of them. Not my client's practice to create handwritten notes or written documents. That's they work in an electronic environment. The significant repository of paper documents, just to kind of clean up that point, is that clients go into, for instance, BSA back, in the 2012 to 2014 period, and we would have expected that those clients would have filled out paper applications to open accounts or whatever it is, signed them and handed them back to BSA, who would then act on them by scanning them in and doing whatever else it is they're doing with them.
Yeah, no, I was not just talking about manuscript notes. I was talking about notes that people make on their PCs.
Okay.
About what's going on. I mean, let's take a board meeting, for example.
Okay.
If we go back to the earliest days and you have a board meeting and you're sent the agenda and all the notes for the meeting and the items, reports and so on, many people would print them off and scribble things on them. Others would make a note on their computer with the document itself and make a printed note along the side or highlighted or whatever. And the question, if you've got individuals with desktops, they may be doing that all the time. And that's, in theory, that's possible to be deleted, you say, but of course you wouldn't know as such. Depends on what the individual does.
Well, I think that certainly we would need to go ask every individual custodian, since we do have a long list at this point, and
we'll come to that.
The claimants want to bump it up to 100 people, so that will take some time. But I mean, we're happy to investigate it. That's not a problem.
Well, I'm just exploring the possibilities. That's
sure.
Okay.
Sure. To the diligence we've done to this point, maybe there are a handful, or one example I can think of. I think in the particulars of claims. So I guess I don't want to overstate my position, but it's in terms of a reasonable proportionate search. We're happy to ask if those documents are reasonably and proportionately available. That's not a problem. We're genuinely not trying to be difficult here.
Okay, emails, network drives, and your third area.
And then the third area is client data, most of which, certainly at the fourth defendant, is stored in these bespoke databases. Avaloq, I think the court has heard us mention this system. Yeah. It's a third-party provided database, but that is run sort of centrally in-house, and that's going to contain the things like trading instructions and call notes, if any. And then there's another system called HyperSuite that there's a long list in our EDQ, and I don't want to get it wrong. So let me pull up what it contains. All right, so page 466.
Yeah, I'm on it.
So HyperSuite contains client KYC, client output, meaning transactions, advices, account statements, etc., and contractual documents with the clients.
Yes.
And then if you go down to Avaloq, that, like I said, would contain contact notes and things like the attribution of the AUM and other financial products of that client to whatever cost center within the bank they would be associated with. So this seems to be a focus of Mr. Shivji's submissions, in his concern that that there were no document retention notices put out until 2013, 2014. So this is, as I understand how these systems work. They are hosted in Switzerland, and whatever rights that the fifth defendant has here are view-only rights. So they wouldn't, their 6-year retention period wouldn't affect the data in these systems.
But does that mean that the fifth defendant has exactly the same material that it can disclose regardless of the fourth defendant's position in Switzerland.
It has view-only rights.
I follow that, but it's
right.
the same material.
But they don't have access to pulling it. Like, we couldn't send an IT tech in there to pull it because somebody in Switzerland has to be the person to give access to the system.
Well, I'm not sure I know quite what that means.
It would be like asking if a viewer here in this conference room had the ability to, provide a copy of the recording of this video conference. And no, they can sit here and they can view it, but they don't have access to the recording unless, of course, the registry provides it to them. It's the difference between having.
I follow that, but could they print it out?
They cannot. It's a pre-lockdown.
On a read-only document, can you not print it out?
We've diligenced this question, and the response has been no.
Well, I think you need to explore that. I mean, I don't know what the answer is, but
there's no barrier to providing the information. It just needs to be done through the appropriate channels. And we would suggest that we've laid out the procedures through which the Swiss regulatory process can work. And
well, I follow that, but if the material is identical and in the hands of someone who can provide it in Singapore, for example, or the DIFC, then there's no problem. We don't even have to go through the letters regulatory process. I doubt if that is the case on everything, but it seems to me it might be the case on quite a lot.
Well, Singapore, for instance, definitely would not have access to the fifth defendant's data. So
I was throwing that out as a possibility, but the fifth defendant is an obvious candidate, being in the DIFC and subject to DIFC law.
And we do understand that, and so certainly to the extent there is client data that is not sitting in Avaloq, because they do receive the account opening forms and that type of thing, then those would be disclosable from the fifth defendant, certainly.
Well, if they've got access to the same material as the fourth defendant has, then even on a read-only basis, I would have thought it was disclosable, regardless of Swiss limitations, but we may have to explore that.
Certainly. In any event, the 10-year provision that Mr. Shibji or that we put in our original letter, and I have to admit that this was upon my reading of the document retention policy. It had a 10 years, and so the clarification that came in our second letter was because it got explained to us that, oh, that's actually calendar year plus 10 years. Now, Mr. Shibji says that this is unsatisfactory because what if a client left early in the process? Now, the process that he's laid out doesn't have any RMs leaving, or even the licensure being changed for, or sorry, not the licensure, but the business plan being changed for the fifth defendant to receive any retail clients until I think it's March or April of 2014. So those are I mean, he's really shadow boxing there. There's no issue of clients leaving BSA and then undertaking services with the fifth defendant in 2013. So the court should not be concerned that there is related data loss for these clients. So a lot of this discussion has focused on notifications, and I mean, notifications are nice. They do let people know that they need to preserve things, but the measures that the fourth and fifth defendant have put in place aren't just simply a memo saying please preserve. These are preventions from deletion. They are a technical note in the system that makes it so that this information cannot be deleted. So we would say that this is far more robust than simply sending out an email or a formal memorandum, and hopefully the court will agree that it's certainly adequate in the circumstances. So there is one point of complication, which is just that the fifth defendant doesn't have a list of former BSA clients. That's not something it natively has, and it's not something that Switzerland can just send to them, again, because of Swiss banking secrecy. So they have done their best to recreate it, but we would say that the party in the best position to say who former BSA clients are is BSA. And if they will sit down with us and have that conversation and hammer out a list that they want attended to, we're again, very happy to go back and double check it. I do want to focus on Mr. Astruc here for a minute. Because obviously it's of great importance and clearly of concern to the court. Our concern with their line of questioning is that at least originally, they didn't come in and ask questions and say, please. They came in with a shot over the bow, saying that we have assumed that you are taking instructions from somebody with a self-interest in this litigation. Now, obviously, Mr. Astruc is a client, so we have to talk to him. So obviously, he is a person from whom we are taking instructions. We're not going to cease doing that. We do take instructions from other people, but the way that they put it is that it also can't be somebody who reports to Mr. Astruc. Now that's just impracticable in a situation where he's the general counsel and we need to report into the legal function. So we are confident. I am confident that we are taking adequately independent instructions. When it comes to investigating document databases, where the documents are, whether or not there's sufficient protections around them being preserved, we are talking to IT. It's not just one person. We talk to one person relates to the email system, another person relates to the client account systems, and we have done, when we say hours of diligence, it's not just a few hours of diligence. Of course we've done our diligence. We're not trying to not look at documents. I actually think the documents will really, really help us on this case, so I'm excited to get into it. But this just isn't a circumstance where Mr. Astruc is calling the shots and directing us away from relevant document repositories. Excuse me. And in addition, when it comes to creating something like a custodian list, we know how to run a disclosure exercise. I mean, I think if my firm is known for anything, it is for tort mega litigation in the US, where if you had a case with only a couple million documents, that would be considered a small case. We know how to run a disclosure exercise. We know how to get the information. We take our duties very seriously. And although Mr. Shivji cites to the solicitors, I don't know if it's guidance or regulations, I mean, those aren't strictly applicable to me, but I think there are probably broadly analogous terms applicable to me in the US, which I take very seriously and adhere to. So no, of course we're not going to just sit and let the client run a disclosure review exercise, but we do have to ask them for information. And there's simply no way to avoid both Mr. Astruc and somebody who reports into him. And I do think that if we were ordered to do so, it would be a gross intrusion on the attorney-client relationship and an intrusion into what I would consider to be privileged communications.
Has he got a deputy?
The person we are taking instructions from is very knowledgeable about legacy BSA matters, and it is somebody who reports into him. I don't know that you would necessarily call him his deputy, but...
Well, is there a number two? He's general counsel, as I understand
yes.
it. He presumably has a number of staff.
He has a number of staff, but there's no one number two. There's no designated deputy.
Okay.
But we are taking the instructions from a sufficiently senior lawyer who, certainly has experienced opinions about how to do these things. So the potential document destruction exercise that Mr. Shivji mentioned related to the other BSA entities. And that came about upon Mr. Lakshmanan from Alpen writing to the fourth defendant and saying, these documents are past their regulatory period, we're 8 years in now, how about we destroy them? They're being held by the same document vendor that Mr. Shivji's client's documents are being held at. And it basically instructed them to destroy them because those are generating costs. And our client said no. Our client said no, there's an ongoing litigation that might involve them. I suppose if we wanted to get really, those might be considered hard copy documents within the possession, custody, and control of the fourth defendant. So I might have to revise that statement just for that batch of documents, but we would consider that the relevance of those documents hasn't been shown. Because they only relate to the other JVs. In any event, just out of an abundance of caution, our clients instructed that those documents not be destroyed, even though Alpen was suggesting it. And in terms of the server on which the telephone calls were maintained that had the malfunction, I mean, nobody can prevent a technical malfunction of a server. That is what happened in 2017. It is, unfortunate. It would be better if those phone calls were still in their original form and accessible in Dubai, but they just simply aren't at this point. But that doesn't mean that they've gone away. I mean, in terms of, the court asked about whether Mr. Astruc has a deputy, and we appreciate that. But I just wanted to respond to Mr. Shivji's point that it is standard for a board to instruct somebody else when there are allegations of fraud. But in my experience, that when there are allegations of fraud on their employer and there's a continuing relationship between them. This is a very discrete set of events that happened 10 years ago, and it is not, in my experience, typical for a board to instruct somebody else, particularly when the board is fully aware of the events in 2014 and has confidence in what was done and how it was done. In terms of a witness statement, if it is the court's desire that it receive one, we want to facilitate providing one. I wanted to make the court aware that under the Swiss restrictions, and Mr. Mueller can probably speak to this more accurately and succinctly than I can, but we'll have to find someone from whom it is voluntary, and then in order to facilitate cross-examination, that permission would have to go through the letter rogatory process. That can all be facilitated, but I would just want the court to know that those are restrictions because it is a third party to the litigation. They would have to voluntarily show up and provide that witness statement. So it would again take additional diligence on our part to make sure we find someone willing. The GlaxoSmithKline case, I mean, it is what it is, but it also, we would note, is differentiable from this case entirely, particularly because there was a known deletion that happened at the time the defendants became parties to the litigation. Now, those are clearly much more curious circumstances than we have here. And so we would say that some of the commentary around that just simply isn't applicable here. In terms of the Lorelei case cited, we would also note that the request to reveal the person from whom the lawyers were taking instructions was ultimately rejected by that court as the applicant had not shown the relevance. If the court's interested in looking at the case, it can be found in the bundle on page 2176 and 2177.
Is it going to help me much?
I think it's probably a tangential point at this point. Just returning to one point on Mr. Astruc, because I do contend he's been unfairly maligned today. He not only is he a lawyer, but he is subject to FINMA supervision. I mean, he has a critical role in preserving the lawfulness of the actions of this organization. He's only ever served in 3 board positions his entire tenure with this organization, and it's always in circumstances when the entity is being wound up or there's some other thorny issue going on for which you need a lawyer sitting on the board. It's not typically part of his role, and so we would say that the allegations against him are really and sort of unfair boomerang of the fact that he was trying to make sure that the situation was controlled, done lawfully, and wound down orderly. Just going back to one of the first points that Mr. Shivji made, and then I can. I think we can probably move on the agenda, is we dispute the suggestion that Mr. Devenish's witness statement should be read as my clients having reasonable anticipation of proceedings in 2016. Now, knowing that the Al-Kharafis are going to agitate for them is entirely different from having a reasonable belief that the liquidator intended to bring them or was willing to bring them. Those, obviously, we expected that the liquidator would act with independence in making any suggestions. It was not my client's belief that there was any basis to bring a case, and so it was not their anticipation that he would then go forth and bring a case. There was ongoing litigation between the Al-Kharafis and the 4th defendant until after that date. The court is well aware that that finally got put to bed in 2018 by the Court of Appeals here, and that a settlement agreement was subsequently signed in 2020. So certainly after the settlement agreement was signed, and the court's seen it at this point, my clients believed that they had settled any matter that could have been agitated by the Al-Kharafis, and so it's not fair to attribute that 2016 date to them as having a reasonable belief then. The only fair date to attribute to them is the letter before action on the 1st of February 2022, if for no other reason that they hadn't even heard from the liquidator for 2 years before then. And the court will, of course, recall that there were significant gaps in the liquidator's efforts to take things forward. So whatever document preservation concerns exist, we would ask that they be answered within the confines of that date restriction. Those are my comments on Mr. Shibji's submissions.
Right. Is there anything you want to say, Mr. Shivji, in relation to any of that?
Just some I'll keep it extremely brief. Just some short points. I think from my friend's submissions, he seemed to accept that there was at least the possibility of individual custodians deleting data from their own network share, and I think that sort of revelation, as was the revelation about the existence of hard copy documents, rather emphasises why this needs to be set out in a witness statement. I know my learned friend's trying to do her best, but it's exactly what one has. It's a sort of revolving door of points, some of which are inconsistent with what's been said before, and the claimants in the court are none the wiser, and the defendants need to be locked down. So we say that just emphasises the need for evidence. On my own friends about a point that the rules are not strictly applicable to her. I mean, that slightly troubles us. They are. I showed you the CPR. The CPR is brought into the RDC by 2.10, so they are, and it's important that the defendants' solicitors understand that. My third point is that it sounds like there was a request for destruction of documents from Alpen. in 2024. I certainly didn't know that, and nor did my junior. We're investigating whether anyone on our side was aware of that. But that is the sort of information I would expect the defendants to bring to our attention, because it's highly material in terms of the preservation of relevant records. If someone who was a contemporary, who had contemporaneous involvement, is out there trying to destroy records. So it is regrettable that they didn't tell us at the time, and I would like to see that letter. Then the fourth point is, my learned friend said that it wasn't the practice of our client to make any handwritten notes. I mean, again, that's not the sort of thing that one can say, well, probably without having conducted a very heavy investigation. But it's also fairly far-fetched to say that across the organisation, no one was preparing notes a decade ago or more. And then finally, just as regards Mr. Astruct, I mean, this is a point of serious concern for us. He should not be running this litigation for the fourth defendant. He has an obvious conflict of interest. I would have thought that Jones Day themselves would be worried about the position, because it goes to actually whether he's properly authorised to give instructions for the fourth defendant. But it's not good enough, really, for them to say, oh, well, the fourth defendant's board know of the allegations and they're comfortable with Mr. Astruct in charge. I mean, as I understand it, as a matter of corporate governance, which is an area that I have some experience of, what one does is set up a special committee of the board to oversee matters where certain members have a conflict of interest. And taking conflicts of interest into account at board level is extremely important across all developed jurisdictions. So I think it's extraordinary that he seems to be the man running this litigation for them when he has a direct personal interest, and it does seriously undermine the quality of the disclosure exercise. So we think it's all the more important that someone independent is appointed to actually give instructions to Jones Day and ensure the integrity of the exercise. And the ordinary course would be that that person reports directly to the special committee. And your lordship's right. Often what one does is take a deputy or a senior officer. I mean, I saw it recently involving a government where there were allegations involving the Attorney General, and then the Deputy Attorney General gets the front seat. The work is ring-fenced from the Attorney General, and the Deputy Attorney General then reports to the executive. We say this is all very well-worn road, and we're not raising this for nuisance value. It's because we're going through an important process, which your lordship said was critical to the fair hearing of the case. And if actually there has been even sort of imperceptible, unconscious leaning on the scope of the process, so it ends up being biased away from where the problems may lie, then that will not lead to a fair trial. So we say that they really must give the evidence in the formulation that your lordship suggested earlier. So that, my lord, those are my points, unless there's anything else I can help you with.
May I respond?
Yes, I was just about to ask Mr. Shipchi a question there. I'm looking at your paragraph 4 at present.
Yes, my lord.
You addressed me, I think, specifically on A, B, C, D.
And E. That's right. I haven't got yet to F onwards. So they're dealing with a slightly different point. This is a point about understanding the organizational structure, and I will come to that. But I just thought it was different in nature, because A to E really are about the integrity of the process.
Yes. Yes, Mrs. Martin, you wanted to add something.
Yeah. So in terms of Mr. Shivaji's reference to Section 210 sub 3, it doesn't mean that the CPR is always accepted. I know Mr. Berganza is a member of the Rules Committee, and so I think he'll probably be familiar with the fact that there was consideration by the Rules Committee about applying ethical standards that were very specific beyond the sort of general ones that are in place. And there was concern amongst the rest of the Rules Committee that said that each of us are members of various jurisdictions, and we have different obligations at some time. And the court decided that it had, or at least the Rules Committee decided that it had to take account for the fact that different practitioners from different jurisdictions can't be made subject to the rules in a jurisdiction that put themselves in conflict with what it is that they're practicing. So I would quarrel with the suggestion that I am that the ethical rules that I should be paying attention to are the ones issued by the SRA, or that the CPR necessarily governs anything I do here in Dubai, or I'm a Dubai practitioner originally qualified in Washington, D.C. and the Commonwealth of Virginia. I also have Mr. Shivji, when he mentioned Alpen, said anyone on our side. And I guess I would ask him for further information about what that means, because as I understand Mr. Lakshmanan's employment relationship for the past 8 or 10 years, it has been with Alpen and not with BSA. So I where he says that we should have brought it to his attention because Mr. Lakshmanan or Alpen is on his side, I don't quite understand what he's getting at there, and it concerns me.
Just to interrupt on that, I was when I said on my side, I thought I made it very clear. I was talking on the liquidator's side. I wasn't for a moment suggesting that a former employee of Alpen was on our side. I only act for the office holder in the company in its insolvency estate. So when I was saying that no one on our side knew about the letter, I said I've only had time to make inquiries with me and my junior and my instructing solicitors, and we weren't aware of that request. I mean, plainly not aware of that request. So there's no. I'm not suggesting that Mr. Lakshman or anyone else, any of the contemporary witnesses, are on our side, because none of them are. We're independent.
Okay, thank you for the clarification. I mean, in terms of the handwritten notes, it's a fair point. I don't think I can make a blanket representation that in 2014 nobody was making them, and we will diligence and inquire. But what I can say is I've been to these offices. These are clean offices that don't have a lot of paper laying around, and not a lot of obvious storage. They have trading floors with Bloomberg terminals, as one would expect at a financial institution. So this is not, certainly not at this time, a paper-heavy crowd. And again, Mr. Shivji seems to be misstating what my submissions earlier were. He says that Mr. Astruc seems to be running this litigation. What I said is that I'm not going to stop talking to him because he is one of my clients. I can't exclude him giving me instructions on his own behalf. Somebody else is running it on behalf of the bank, and I have complete confidence in the independence of their judgment and their level of seniority such that they have sufficient influence, and so I would just ask Mr. Shivji to please stop misconstruing what I say on that front. In terms of Mr. Shivji's vision of what generally happens in these situations, again, if there is considered to be a potential fraud on the employer, then yes, it is my experience, at least in the American system and the English system, that a special committee of the board takes control of the matters. But this is a Swiss bank, and the governance and regulatory and legal models on Swiss banks are just, we have to kind of like take our common law hat off and deal with reality that it's just not quite the same model. And so the boards of Swiss banks don't get involved in this way, and it is unlawful for them to get involved in this way. So that to set our expectations about what should happen at a governance level according to the standards with which we all learned over our many years of practice, it defies reality. And this is something that was communicated to claimants, and yet they still keep banging on about it. So again, we're very happy to cooperate. We're very happy to provide relevant information and assurances to the court. But we want it to be on terms that are realistic and compliant with Swiss law, is all we would ask.
Yes, well, primarily I'm concerned with the law of the DIFC. I've already made an order for disclosure that requires standard form disclosure because this is a fraud case. And to the extent that any party does not comply with that order, they would have to justify it by reference to whatever system of law they think governs them. And then I shall have to make decisions. But make no mistake, Mrs. Martin, this is a DIFC case governed by DIFC law, and the rules of disclosure apply just as much to your client in Switzerland as they do anywhere else in the world. In this case, what we've got is an allegation of fraudulent conspiracy made against a number of defendants, including the individual directors and Mr. Astruc, who is the general counsel. In those circumstances, it seems to me that he can't be the person who is responsible for decision making because of the allegations made against him individually. Of course, he will give instructions on his own behalf to you, Mrs. Martin. That's inevitable and must be the case insofar as you act for him as well as acting for the others. But when it comes to disclosure, someone independent from him has to be the person who takes responsibility for decisions. And it's also true to say that not only must there be independent supervision by someone else of sufficient seniority and responsibility on behalf of the fourth and fifth defendants, but there is a need for supervision and direction by the lawyers involved, namely Jones Day. And whatever the position of your ethical responsibilities as an American lawyer may be, your duties here apply to you as a DIFC registered counsel. And in the context of this case, and I emphasize the context of this case, I've made orders for a much more wide-ranging form of disclosure than would ordinarily be the case because it's a claim in fraud. And in those circumstances, I have specifically made orders that bring in the practice directions from the UK in relation to disclosure, which I'm entitled to do under RDC 2.10, and that I have done. So in this case, I think there is sufficient doubt about the integrity of the process conducted thus far to require there to be a witness statement pursuant to RDC 2814 to be filed and served by a senior officer of the defendants other than an individual defendant who must address the points raised in A, B, C, D, and E of paragraph 4 of the draft order for directions that the claimants have produced. As to paragraph A, it must actually specify who are the individuals who are responsible for giving instructions so that the court can be satisfied as to the process. Now, it may be that in relation to the whole question of document destruction and what documents exist and so on and so forth, that more than one person will need to be involved in the witness statement. And that's a question, I think, for you to determine. But there does need to be someone who's of sufficient seniority to supervise this, to make sure it's all being done properly and as it ought to be, and that full and proper explanations are given as to what kinds of documents do exist, don't exist, once existed but no longer exist, document retention policies, document destruction policies, exhibiting them as the case may be, so that we know exactly what there is to be had out there. And that, I'm afraid, has got to be done fairly quickly because unless we have that, the whole process of dealing with disclosure is going to be held up. And although on the face of it, we've got plenty of time until a trial, one knows that time flies by as soon as you get into document production of any kind. So the first question, I think, Mrs. Martin, is whether you're in a position to identify today who will put in that witness statement.
I'm not. We haven't been talking to any single one person. My apologies for interrupting. Okay.
And it may be that you will also want to put in a witness statement from a solicitor too, from Mr. Devonish or someone as to his investigations as to what he's been told as to what there is and what exists and what doesn't. The other question, apart from individual, is what time you need to do it. Does it make sense to deal with timing later when we see what else there may be that you've got to deal with?
That probably does make sense.
All right. Well, let's leave that point to one side for the moment then.
Okay, thank you. I might flag just in advance while we're all thinking about timing that I have a gap when I won't have anyone to take instructions from at the client, just because of personal travel schedules for the types of family events that you don't miss. So they're just sort of June 20th for a couple of weeks gets very tricky for us.
Right. Okay. Well, let's try and find some way around that when we get to make the orders.
We'd be grateful.
All right, where are we going next, Mr. Shivji?
Organizational structures, my lord. I'll try and take this really quickly. I think the correspondence is, I think, probably headed down the wrong direction on this. What we have made clear that we're after is simply trying to understand within the bank what the structures are for decision making and who were the individuals to sit on the relevant points of the structure at the relevant times. And I'm not saying for a moment that all of those individuals will need to be custodians, but one of the real challenges in a fraud case where a bank has made decisions at a very senior level and then have been executed is understanding the individuals involved in the layers of the process. And you just don't, as an outsider, you just have no visibility on that. And that's why there does need to be some transparency from the bank as to what it was doing. Now, as I said, whenever we've written about this, what the defendants have said is, you're adding 10 more people to this, the custodians, or 15 or whatever it is. I'm not doing that. I simply just need information about who it was in the bank doing these functions. And then we will go away and come up with a sensible list of proposals as to how you might tackle disclosure for those different layers of the structure. Although we haven't had engagement from Jones Day on this, they do understand the theory of the point because they asked for exactly the same thing for us. And you can see that at 2352 of the bundle, which is their letter of last night. Right at the bottom of the page, they ask us to provide to them the documents in our client's possession detailing BSA's internal structures, committees and allocations of competencies to allow us to ensure that all relevant custodians are captured. So, I mean, that is exactly the point. They're just trying to put the shoe on the other foot. So I don't want to spend too much time on it, but the different categories that we have chosen on our draft order are driven by what we know has happened within the bank in terms of the decision making for these activities. If your lordship goes to 1838, which is my learned friend's skeleton argument.
Paragraph?
Paragraph 4. And unsurprisingly, the way she characterises the issues in the case, I'm not entirely aligned with. But she says, beyond debate that BGSS was fully entitled to wind up BSA, particularly as against the backdrop of a sale of BSA being effectively impossible. The controlling question is whether it deputised, so that's BGSS deputised, BSA's directors or officers to breach their duty in executing the wind-up. Now, and we've had this theme throughout my learned friend's submissions that their position has always been there was a winding up, which was led at the highest level by BGSS and its parent company, but that the activities were lawful. So, and we know that it was a sort of top-down exercise because they had previously given us extracts from the board of directors of BGSS and also JSSH, and that's at 611 and 612 of your bundle. And I should also you remember all that. And I should also say, my lord, that it was all given to you without any concerns about banking secrecy or the Swiss criminal code. And it's material surrounding these decisions and the execution of the strategy within the organisation that are really going to go to this fraudulent conspiracy. So I'll come back to banking secrecy later, but I think sometimes the banking secrecy is overblown because actually this is a case in conspiracy, and we're going to see, and it's a case in conspiracy where they admit essentially some of the activities that led to the transfer of the business, but they say that they were lawful activities and we say that they were unlawful. But because we know it was a top-down exercise led by the board, one can start to work out the layers of the structure that must have been involved in it. And there is a document that we've been given at 514, which is called the allocation of competencies for the fourth defendant. And what that document, it's a governance document, and what it does is it identifies different sorts of decisions and where those decisions need to go in the organisation to get the right approvals. And essentially this document is how we have identified the categories that we want information on the identity of the membership for. But just to pick them up swiftly, on 515, my lord, let me just tell you what the abbreviations are, because they're a little bit baffling. VR is the board of directors, CEO is obviously the CEO, GL is the executive committee, GBL is the head of division, and GFL is the head of a business unit. And really we're focusing on the more senior aspects. So we're interested in the board of directors, executive committee, chief executive, and head of division. And if I take you then through to 516, I can just identify some of the sorts of activities that we say this case obviously raises. And so you would expect within that structure those individuals to have looked at this. So the first is at 516, second line, conducting legal proceedings as plaintiff and defendant with a disputed sum of in excess of 1 million. Well, obviously the Carafi litigation fell into that, and that involves the board of directors and the CEO. Then if you go down to the fourth item, strategy, long-term planning and controlling, that's the board of directors. And of course, the decisions about the strategy they followed in the Middle East is obviously long-term strategy. The next one is the business plan, budget and business plans for the entire bank. So the business plans for the entire bank would include their Middle Eastern strategy. That includes the board of directors, the CEO, and the executive committee. Then there's issue, if you get further down the page between the hole punches, issuing regulations for interdivisional business operations. That involves the board, the CEO, the executive committee. Then a bit further down, strategy, midterm planning. That is the board of directors, the CEO and executive committee. Sorry, board of directors, CEO and head of division. And then similarly, organizational structure. And at the bottom, founding, acquisition or sale of companies and holdings. That, again, all of those are board, CEO and head of division. So I know I've taken that quite quickly, but one can see that those four parts of the bank that we're interested in, the board of directors, the executive committee, the CEO and head of division, are involved in many different aspects that must have been triggered in relation to the Carafi litigation and the decision to have a new Middle Eastern strategy to divest of BSA and to incorporate the new subsidiary. So that is how I've come up with my list at 1779. And if we go to G, G Roman 1 is the board of directors. The next one is the executive board, then the chief executive officer, and then the fourth one is the head of division. And we've identified what we understand to be the relevant division, which I think is currently Mr. Sassoon's role. So that's Roman 1 to 4, which covers D4. On D5, we don't have the same level of visibility, but we've assumed that there's a similar structure, but pared down because it's a much smaller organisation. So we've gone for the board of directors, the CEO, and the executive committee, if any, and I don't know if there is one or not. Then Roman 8. That's the board of directors of JSSH, and we know that they were involved because at 612 is the board minute concerning the winding down of BSA. And then 9 to 11 deal with something slightly different. A regulated investment bank, so a regulated Swiss bank, will have conducted investigations into the allegations here. I mean, my learned friends, in fact, are specialist in this field, as I understand it. Her firm certainly is, in terms of regulatory investigations. There will have been internal investigations. There are probably external ones as well. Those investigations will need to be searched. And I mean, when the shoe is on the other foot, my learned friends say that we should be searching the liquidators' investigation documents for relevant material. And of course, when we come to craft our searches, we accept as a matter of principle that we ought to be looking, amongst other things, through our investigation files. But it cuts both ways, this. In principle, the bank needs to be looking at its own investigation. And your lordship will know from other matters, I suspect, that the law of privilege has developed on this front. But actually, it's now clear that these sorts of internal investigations are not covered by litigation privilege. So insofar as there were interviews with employees, or documents created or internal reports prepared looking into this, that all material would all be disclosable. And so we say at least fruitful at this stage for scoping out the disclosure exercise. But I'm not looking for a list for 9 to 11. I'm not looking for a list of every man and his dog who would be involved in the organisation worldwide. What I'm trying to capture is the investigation teams and compliance teams who would have looked at the complaints in this litigation. And if my learned friends want to provide us some information on how that was done and who that involved, we could very substantially reduce the scope of those categories. And I'm certainly not interested in examining bits of compliance that are completely out with this litigation. The compliance team obviously also have an involvement because of their communications with regulators. We know that there was correspondence between D5 and the DFSA. Regulators, FINMA as well, would have asked questions about this, and the bank would have had to give reports to the regulators, and that sort of material should be included in the disclosure search. So, my lord, that's what we're trying to achieve with G. In 4G.
What about the dates?
So, I mean, again, I think I'm quite open-minded to discussion with my learned friends about trying to narrow down the dates as much as one can. For something like the compliance team and the internal investigations, that will have inevitably happened later. And so there probably is no need to look earlier. Similarly, for the real involvement at sort of executive level, that probably happened earlier more than later. But I mean, I think we need some transparency from my learned friends as to really where we should be looking. But and all I want at this stage is just a list of the people involved. And if they can actually help us by saying, look, we can tell you that the internal investigation ran from 2016 to 2018, and therefore you don't need to, we've looked at this and there's nothing that happened before 2015, then it makes it easier for us to say, okay, fine, we can put that to one side. So my lord, that's how 4G came about, and I would say that this that we haven't had the level of engagement that we were hoping for from the defendants, and if we had, these sorts of things really ought to have been agreed rather than being argued before your lordship. But anyway, sorry, going back then to F. F is just some sort of organisational structure. Financial without being unfair, financial institutions love producing these sorts of things because it's useful as a matter of internal governance to know how the structure. So actually, this sort of material ought to be easily accessible. There will be some department somewhere that will keep these sorts of records, and they will just be able to tell you how structures evolved over time. And then H is just the allocation of competencies. Was that updated? I've shown you the version that was given to us, but there may be other internal policy manuals, etc., that they ought to give. So, my lord, that covers F to H. The point about I is a really short point. Obviously, insofar as the lawyers were involved in matters that are privileged, then none of their work would be disclosable. But in the fifth defendant's correspondence with the DFSA, it suggested to the DFSA that it might want to correspond with Herbert Smith. And that is in the bundle at 595. I mean, we don't actually need to turn that up, but that was what they suggested as a possible point of contact to the DFSA. So Herbert Smith might have handed some inter partes correspondence that would not be privileged. And so someone needs to think about how to conduct the searches there. Again, we don't need every person down to paralegal involved at Herbert Smith, but again, some sensible identification of perhaps the partners and senior associates involved there and how that exercise might be tackled would be helpful. So, my lord, that really is the point about unpicking the structure and the people involved. J and K go to something else. So again, is it useful if I paused at that point to hear if your lordship wanted to hear from my learned friend?
Yes, I think so. I mean, Mrs. Martin, all of this sort of stuff I would have expected to have been dealt with in correspondence long since, really, just as a point of discussion between the parties as to how the disclosure exercise was going to be carried out. I mean, is there any real difficulty about any of this?
The real difficulty is that this is the first we're seeing these. On Friday, we received this list that they put forward, and we haven't had any engagement from them. We can both. It's very boring. I could take the court through the dates on which letters were supplied and responded to, and the sort of length of their letters versus the length of ours. We think we've provided a lot of information as quickly as we possibly can. They always, the first letter we received from them was, I think, the day before or maybe 2 days before the last hearing. That was 2.5 weeks ago. And in every instance, they've asked for turnaround on a 2-day time frame, which is just impossible for the breadth of questions that they're asking and the number of issues that we have to investigate. We're very happy to engage. If I were the court and if I could lodge a suggestion, and I have clerked for a court, and this is something we did, I would order the parties to go sit in a conference room and hammer this out themselves. I find that people get a lot more cooperative when they have to sit across from each other rather than just sitting behind their keyboards like warriors firing off missiles, accusing the other side of things. So with all that being said, there are probably some difficulties with disclosing third-party names, again, according to Swiss law. And but I think on a lot of this, Swiss bank secrecy won't necessarily come into play because it doesn't involve client data. They are in possession of the allocation of competencies from the relevant time. It's just that they've expanded the time frame that they want things for 2011 to 2018. So even though this is the first we're hearing again that these time frames are negotiable, what we had understood is they're asking for this incredibly overbroad time frame. We're happy to negotiate. We're happy to provide the information that we can provide in sort of an open, non-letterogatory facilitated manner, but their engagement has been last minute and not constructive. The reason, for instance, if we could go to 612, the extract from the Board of Directors meeting. The court will note that there are no client names discussed. There are no other names included here. So, of course, we were able to produce that from Switzerland. As explained by Mr. Mueller, this is information over which the bank can freely disclose. And we're very happy to do so in circumstances where that is the case. Yet again, the points about that they created this list by looking over the allocation of competencies. This is the first we're hearing about this. Like we've never had that explanation before. In terms of the investigation, whether or not that's reciprocal, what I would say is that the liquidator has a statutory duty to investigate the affairs of the company, and that is not inherently privileged. We would expect that there are many, many non-privileged documents associated with that inquiry, even if lawyers were involved. On our end, any sort of internal investigation for legal or regulatory purposes is at least presumptively privileged, and so we're on different footing in that regard. Now, if the court thinks it's helpful for us to go through that and create a privilege log and then take decisions on whether or not to waive privilege, that's something we can undertake. I think that's probably not reasonable and proportionate in these circumstances, but that remains a point of dispute between the parties, whether or not they're on equal footing for the investigations. In circumstances where they haven't given us sort of bespoke date ranges for each of these subcategories, and a lot of what they're asking for relates to large departments, such as the 33 current compliance officers, and if you look at the list of employees over time, it's going to be massive. I don't know that there is a way to narrow that down to one or two custodians or whatever the reasonable number might be to facilitate what they want in that regard. And even more expansive than that, where they asked for something related to the reputational risk team, there was no reputational risk team per se at the fourth defendant. The fifth defendant is far too small to have a team like that. So that's, I mean, off the top of my clients' heads, they could think of 30 different people who might relate to a team like that, but no one team. That's just not a practicable solution. What we would ask is that rather than ordering something today, that the parties go back and for any applications or suggestions along these lines, that they go back and they tie these requests to the list of issues that they have provided to each other. And granted, they haven't agreed on their list of issues, but if they can at least tie it out to their own, then I think it would make sense for that to be baked into an order for the court to order it. If there's any disagreement along those lines, then the parties, again, can come back with applications as to what exactly the disagreement is. But we think we've been provided too little information too late with the lack of specificity as to date ranges, as to what it is that they're really looking for. And our concern is that this is going to become a game of moving goalposts that will do what we think they're asking for based on this lack of specificity. And they'll be able to come back and say, no, you didn't produce the right documents, and now these inferences should be held against you. We want to prevent that. We want this to be done the right way the first time. So we would ask that the parties be asked to go away and agree on these things before the court necessarily becomes involved in them.
Well, the only real issue appears to me to be date range, really, and that's the question of trying to isolate which dates matter in relation to which issues in the pleadings. And I should have thought that ought to be capable of being agreed. Certainly, you would have some idea what exists, but the identity of the people concerned and the various stages where it matters. Are we not in a position to identify those here and now?
I think that we have different views. The date range that they've put forward is almost universally 2011 to 2018. So I don't have any different information to suggest that they think that the date range is narrower.
What would you suggest as an appropriate date range?
Well, other than some,
obviously, we're talking of 2012, 2014, 15, something of that kind.
Yes.
That would appear to be an obvious date range in relation to the activities that are said to
that is what we would suggest. We would
constitute the fraudulent conspiracy. But then there are questions about steps taken in relation to the Al-Kharafi litigation and so on and so forth, which covers a wider range. So there's a question of what dates are involved then.
Well, that would certainly cut off by the 1st of May 2016, when the fourth defendant became no longer responsible for the affairs of BSA.
Yes. So what are you suggesting for the moment then? So
our proposed beginning date range is the 1st of October 2012, which is, on our view, when the disagreement between the shareholders of BSA became apparent, leading to BSA's wind down. So that's what we would propose for the beginning of the date range for the activities related to the allegations. We would propose that end by December, end of December 2014, if the court wants to go into January when the last personnel left. That's not offensive, but we don't think it's entirely necessary. And as
when you've picked the date in October 2012, is that the first indication that there was a problem in a change of strategy in relation to the products that were going to be offered, the leveraging and so on and so forth.
That is when Herbert Smith was retained.
Yeah, that's not the same question.
I think that the problems in the business model became apparent almost immediately upon acquisition. So that would be July 2012.
Right. Well, that seems to me to be a logical point to start. And then we take it through at least to January 2015. But what about then the whole question of the litigation? I'm aware, obviously, there are issues about privilege and so on involved, but there's already been waiver of privilege in relation to some advice. Query whether it's advice given to the company in liquidation, or whether it's advice given to the fourth defendant and fifth defendant. But
I don't see a reason to back up the search range before 2012 unless Mr. Shivji.
No. I don't think anybody was suggesting that, really.
All right.
It's the question is. Question is up to what point, therefore, do we need to go in relation to the Al-Kharafi litigation? At this stage, all you're being asked for is to identify the people concerned in whatever date range matters for the purpose of the pleadings.
Yeah, I mean, I would suggest that the Al-Kharafi, the goings-on at my clients in relation to the Al-Kharafi litigation ceased to become relevant to BSA once it was wound down. I mean, it was just a shell at that point. I don't think there's any dispute about movement of money or anything like that. So I don't see a reason to take that date forward, but if the court is inclined to take that date forward, I would suggest it should go no further forward than the 1st of May 2016.
Mr. Shivji?
Thanks, my lord. Sorry, I just want to correct one point. My learned friend's submissions rather gave the impression that this was a new list that we sprung on them on Friday. We wrote on this on the 21st of May, and if your lordship looks at 1575 of the bundle,
I don't want to keep going back over history. I'm trying to work.
I understand. I won't dwell on that. So in terms of the start date, it does need to be, as you say, some point before Herbert Smith was instructed. If this is only in relation to identification of individuals, so if they're starting, let's say at the beginning of June 2012, that for the time being, that's fine. For these purposes, that's fine. In terms of the end date, it depends what you're looking at. If you're looking at the conduct relation to the winding down of the business, well, then May 16 would be a sensible end point. But if you're looking, for example, at the business that the fifth defendant appropriated and held and the money that it made from its client relationships, you would need to go later. And then also similarly, if you're looking at the internal investigations, that inevitably will be later. And it may well be that at the point, I mean, you've got these issues surrounding the regulation of the fifth defendant, and then you've also got questions of what internal investigations were conducted, and that would happen later. So I think that's why I said our sense is that some pieces one could go earlier with and other pieces you should go later with. On the internal investigations, they are not prima facie privileged. They're actually prima facie not privileged because they're internal investigations for the purposes of actually understanding what happened, not for litigation. So, and my learned friends, she can't have it both ways. Her position is on the contemplation of litigation, that it wasn't in contemplation until 2022. So she can't then say that there's a litigation privilege that applies to it. So, so I'm open-minded about that. But I mean, our sense is that it is worth locking the dates down because it's been kicking around for some 3 weeks in correspondence, and it's not going to be resolved without your lordship's order.
Right. Well, tell me what dates winding down of the business, we'd agreed June 2012 to May 2016. Doesn't seem to be much issue. What about the appropriation of the business and so on and so forth? What dates apply to that?
Well, I mean, we've only asked for that information up to 2018, but it would only apply to the fifth defendant. So I'm content to say that for the information, so, what we could do, my lord, is looking at my G1 to 4 could run from that date from 2012 to 2016.
Yeah.
5 to 8 could run from 2012 to 2018, but bearing in mind that there are going to be likely very few people in that catchment area, certainly in the early years. And then on 9 to 11, perhaps we could go from 2015 to 2018. And I'm very open-minded on that. If my learned friend says these are the individuals who were involved in either discussions with the regulator or internal investigations, and it was this team, then that would sweep away the other 32 people within the department who probably had no involvement in this.
Well, Mrs. Martin, how does that strike you?
Well, I still have a bit of a problem on the Roman net 11 where there just is no such thing.
Well, if you don't have a reputational risk, Dean, that's that.
Okay.
I find, sorry, I didn't mean to
interrupt. What we're looking at is those who are involved in compliance and regulatory matters and internal investigations and the complaints that have been made. And the question is identifying those who are involved in those areas. That's what it comes to, doesn't it? And by which one doesn't mean down to the last secretary and PA. One's talking about those who have executive responsibility of some kind, who ought to be identifiable, one would think. I mean, I don't really have any sense how large the bank is in terms of its staffing, but
it's approximately 2,000 employees.
Yeah.
So sorry, Mr. Shivji, just to clarify, it was on 9 through, no, sorry, 8 through, no, 9, 10, and 11. 9, 10, 11.
2015 to 2018, he's suggesting.
And just you want members of the compliance team, insofar as they had any
involvement with the first claimant or fifth defendant. And this is compliance, internal regulations, however you want to look at it. But it's, when they've carried out these things to try and work out what was going on and so on.
Well,
who was taking responsibility? Okay,
but can we need to narrow it further, because the compliance team's principal roles is approving transactions or doing regulatory compliance around transactions. So that.
Well, we're not interested in that.
Okay, so we can excluding that. I think we can work with those dates. Can I just take instructions very quickly? Dates are okay.
Okay. All right. So have we sorted out 4G now? And what's left next?
I think we have. And on F and H, if the answer is that there is no other allocation of competencies aside from the one that we've been given, they can give that answer. But right. This is a very small pool of documents. These manuals are probably refreshed once every 5 years. So I think I would just say that keep those dates for F and H.
They might look at it once a year, I suppose, but who knows? Do you have any feel for that, Mrs. Martin?
I think it's every couple of years, maybe. But
well, in which case it's not a problem, is it, really?
Well, we'll deal with it. I guess just again, when we get to the timetabling, I just wanted to kind of make a flag that we're going to have to do some investigation on these, particularly these last 3 points, and so I don't think it's something we could turn around in something like 7 days.
All right, but you know, we're not looking at an enormous volume of documents if it's something that's being done once every couple of years.
Yeah.
All right, okay. On we go.
I think Mr. Shivji, you're on mute.
Thank you. Sorry, I was just speaking to my junior. Excuse me. So my lord, we had a couple of slightly smaller points at J and K, for J and K. I do want to preserve my rights on those, but I'd rather pick those up in correspondence and not spend time on them today. So if I may, we'll come back at another stage if we can't resolve those. Can I move on to deal with this point about the list of BSA's clients? Now my learned friend seems to be proposing an exercise where the list is agreed ahead of disclosure. There is a slight chicken and egg to this, because of course it's the fraud case. We don't actually know about the full extent of the fraud, and we'll only have a better idea once we've seen disclosure. So one can't come up with a final list of clients until we've had disclosure, and if they were only able to limit their disclosure by reference to the clients we could identify, then we would never find out about the full set of the piece. As we understand it, and their pleaded cases, that the fourth defendant was required as a matter of the Swiss regulatory regime to keep a list of which agent or which firm the client relationship was handled by, and whether it was chained from BSA to the fifth defendant. And that's in their defence at para 158C, which is page 208 of the bundle. So they ought to have a list. Now they say they can't provide us with that list because of Swiss banking secrecy. Well, they will need to when they give disclosure. But I think in light of the fact that the fourth defendant has that list, we find it very difficult to see why we need to provide another list, which in all likelihood won't accord with their own list. They should just work off their list, and we'll get disclosure of it in due course. And the suggestion that we need to give the list because they can't give it to the fifth defendant seems rather far-fetched. I mean, my learned friend said to you earlier that the fifth defendant has viewing rights on this platform. So the fifth defendant should just look it up themselves. They can log onto the system and they can have a look.
No, Mr. Shivji, I'm sorry. The fifth defendant cannot view non-fifth defendant clients. So their viewing rights are limited to their own clients.
But they will know who all of their clients are.
But they won't know who BSA's clients are.
But they didn't need to know that. They'll know who all of their clients were. So that gives them their position. And then as regards BSA's clients, I find it actually quite. I mean, presumably the defendant's position is that the liquidator could authorise BGSS to give that information to the fifth defendant, in which case you can write to us and ask us for that authorisation. I can't see that being an obstacle. But it seems a slightly unreal position that we are having to try and unlock the distribution of information between the fourth and fifth defendant, when in reality, at the relevant time, all of this information was shared and they worked together as one team. But in any event, we have produced a list in our pleading of all of the clients who received termination letters that we were aware of. And if your lordship goes to page 69 of the bundle, and if your lordship just scrolls down, it runs for pages. So that was our best stab at that point in time of the termination letters that those clients received. And then in any event, as the fifth defendant, whenever it onboarded a client, would have had to understand where that client was coming from, just as a part of the KYC. So, I mean, again, the idea that the fifth defendant doesn't know whether the clients came from BSA seems totally unreal. I mean, especially given that most of their workforce were former BSA relationship managers who were hired in order for their client relationship. So this all just seems like a device, I think, to try and pin us down to a smaller pool of clients that only we know about at this stage, and that we never get to open the door for anyone else who we didn't manage to identify. So, I mean, I don't, as a matter of principle, at some point in this case, we are going to have to nail down a list of the clients, but that's going to happen after disclosure. And we say that they've got enough information at the moment to get on with it. And we don't accept that there's any genuine obstacle on their side that's stopping them from progressing their own disclosure.
What was the reference you gave me to the points of defence?
That was paragraph 158F sub C, and that's page 208 of the bundle. Can I just show that to you? Because the pleading is a little bit obscure, but actually you can discern the point from it. So it's under C towards the top of the page.
Page
208. And I think it's in response to some plea about whether or not they should have rebooked clients from BSA to the fifth defendant. And they say if BJSS had failed to rebook the revenues of clients upon receipt of the client's instructions to register and reflect that the client relationship was handled by BJSS AM, its own books and records would have been rendered inaccurate, contrary to its own Swiss regulatory requirements. So the point seems to be made is that under their Swiss regulatory requirements, they were required to have accurate books and records on who the client relationship was handled by. And so if there was a switch from BSA to the fifth defendant, they had to make that switch. And so that's why we say it should be on their system.
Yes. Right. Mrs. Martin?
It's simply very difficult for us to understand why the party in the best position to list and identify BSA's clients is not BSA. Surely that is information within their possession, custody, and control. The exercise of trying to weave together who those clients were at either the fifth defendant or the fourth defendant, to the extent any records are available at the fifth defendant at all that are relevant, because there's simply not a box in a database that says former BSA client. The way I understand the Avaloq system is it's a structured system, meaning it's sort of it's a database. It has various fields, and the attribution of the sort of cost center to whichever client to say where their AUM and other related revenues would go doesn't maintain historic data. So when that was changed in 2014, it was changed in 2014. Now, can we maybe go through and try and find printed out lists or lists that were created for other reasons or something else? Yes, but that's going to be a real exercise. That is not something that can be done this month or next, or it's going to be a real exercise of stabbing in the dark. And again, there's just the fifth defendant doesn't know who the former BSA clients are, and so even if we can come up with a preliminary list proposed by Mr. Shivji, and we can search on that basis, that at least gives us a big running start to where we are now, and removes a lot of the cost and expense and time and energy away from the process of just trying to recreate the state of affairs in 2014. What the paragraph that Mr. Shivji pointed you to says is that they had to maintain accurate books and records. That doesn't mean they created a list for the purposes of delivering it to a regulator and that list is stored in a vault somewhere. It just doesn't work that way.
I regard this dispute as utterly ridiculous. I mean, on the face of it, the liquidator knows who termination letters were sent to. That's been feeded. You have a list. It seems to me you ought to be exchanging lists and comparing the two. I mean, there's no difficulty in the fifth defendant producing a list of all its customers. There's no difficulty in the liquidator producing a list of those whose contracts were terminated. Just compare the two. What's the problem? Can't I make an order that you exchange lists within 7 days?
For our part, my lord, I'll be happy with that. I mean, I think just so that I can clarify on our side, what we don't want to have to do is run a standard disclosure exercise across all of our documents to see if there are any additional names that we're missing. So we've got what we've got at the moment. As we get disclosure, we might find more names, and I don't want to be pinned down on a list for final purposes. But if your lordship wants us to produce the list,
I haven't
the best one we can.
Let's get started, you know.
Yeah, no, I understand that, and I see the force of that. And for our part, I'm very happy if we can do our provide what we can now on the basis that this is the best that we can do now, and it's not definitive. We're totally happy with that, and we could do that. I'll get instructions, but I think we could do that within 7 days.
And this is, you know, the material that's being exchanged is material that can't be used for any other purposes. So what's the problem in exchanging lists?
I would just ask that to the extent that the fifth defendants list might include clients who were never clients of BSA and so really irrelevant to this dispute, that whatever confidentiality restrictions are necessary be put in place. So it's really not fair to those clients.
That's my point. You know, everything here can only be used for the purposes of this litigation. It's all confidential. You'll reveal a whole lot of names, perhaps, who were never clients of BSA. That's easy. No problem.
Can we pick a date again?
Yeah. 7 days. Oh, you mean the date of them?
Yeah, the date as out they were clients. I don't.
Right. I mean, well, that's more difficult, isn't it? What suggestion would you like to make on that?
We propose to the claimants that we pick a mutually agreeable date of when they were clients at BSA for purposes of searching the defendant's records. Which we would propose end of July, I'm sorry, March 2024. 2014, my apologies.
I think, my lord, we might have to choose a date range, because I can already detect that this is a super difficult question, and I think that what I think on our case, what one sees is customers moving over a period of time. This is a moving.
Yeah, well, I understand that.
So I think, sorry, my lord, I didn't mean to cut across you.
No, you carry on.
Yeah, so it may be that we really have to say something like who were customers of BSA at any time from 2012 to 2014 or something. Looking at my junior to make sure I'm not saying anything that commits him to doing an enormous amount of work that he doesn't want to do. And so I think maybe that's that sort of range, my lord, to 2012 to 2014, and then we'll just do the best we can on each side to come up with a list, knowing that it's not definitive, it's just one's effort at this stage.
I would ask on what basis the pre-scheme dates are relevant. We would suggest a narrower range on the BSA side. We're happy to go up again to the 1st of January 2015 date on the fifth dependent side.
Starting from what point?
From whatever the end of their, well, from what would I propose? Probably 1st of May 2014. I don't think actually any retail or private banking clients were onboarded until actually the 2nd of June is the first one that was that were onboarded according to the records that we have that are the date of the TOIS letter. I'm sorry, according to.
This rather reveals the point, my lord, that they're they know they've got this information and they know what they've got, and then we're being pinned down, and we fraud was committed on us, and we weren't even there at the relevant time. So we're reconstructing all of this, and I don't know when this scheme started, and that's why we've done the best we can in our pleading. But they know. So I'm in your lordship's hands, but this is all rather unreal because they have information at their fingertips as to when, like my learner has just shown, as to when people went across and when things happened, and we don't have visibility of that in the way that they do.
Well, the date that I'm going off of was provided by the claimants. It's page 69 in the bundle, and it is this schedule of TOIS letters provided by the claimants.
But that is, sorry, I appreciate the tennis.
Well, why don't I just say lists of customers? in the year 2014. It's as simple as that, isn't it?
Yeah, let's start there, my lord.
Sensible.
Start there, and if it requires refinement later, well, so be it. But at least we'll get the vast majority in. 2014, right.
So, my lord, I think we're then moving on to the item 2 of our agenda. We'll deal with these items swifter, I hope, which is to do with standard disclosure and the Swiss law restrictions. I mean, in light of some of your lordship's earlier observations about the applicable law being DIFC law, I can deal with this very swiftly. There are essentially 3 points that we rely on in relation to these Swiss law restrictions. First, that they've misunderstood where the restrictions come into the legal analysis as a matter of DIFC law. Second, in any event, the restrictions as identified don't prevent the defendants from discharging their obligations under DIFC law. And third, that the order that they've come up with is unnecessary. So just on that first point, that they've misunderstood where these points come into the analysis, they're subject to an obligation of standard disclosure. That's been ordered and they agreed to that. And if their position is that due to a foreign law restriction, they simply cannot comply with the court's order, then they will have to be asked to be released by the court. And they will have to demonstrate to the court that there is a real risk of prosecution for a criminal offence if they are not. And that's the Bank Medat decision. It's a decision of Lord Justice Gross. And in fact, some of what your lordship said earlier on effectively reflected the first and second paragraphs of that authority. I suspect your lordship has seen it before. I mean, the essence of it is that it's DIFC law that reigns supreme, and there needs to be a real risk of prosecution, not some fanciful risk. And even then, it will be a question for this court to decide in balancing the interests of justice in terms of giving disclosure as against the purported risk that the defendant faces. Now, actually, in this case, there has been no suggestion from the defendants that there is a real risk of prosecution. What they're saying is that they want to go through this letter of request route, and they say that that has some mechanics which need to be built into the process. Now, that brings me on to my second point. The points that they have identified do not prevent the defendants from discharging their obligations under DIFC law. In fact, the points they've identified doesn't suggest this is going to be any genuine obstacle at all. But firstly, on their analysis, these restrictions under the criminal law and in relation to banking secrecy will only apply to limited categories of data. They plainly don't apply to the fifth defendant, and in fact, they're doubtful they apply to Mr. Carton, who they previously said spends most of his time these days living in the US. They haven't actually made any real effort to isolate the likely specific and limited categories of documents which are caught by these points. Second, these purported Swiss points don't actually prevent them from carrying out any standard disclosure searches. And there's been no suggestion either at any of the previous hearings or today that they are prevented from just getting on with the exercise. And that brings us to the next point, which is that they say they can obtain permission from the Swiss court to disclose these documents under a letter of request procedure. They say the Swiss courts will want to make a more specific order rather than a broad one, but their searches will allow them to categorise the documents or, if necessary, provide a list to the Swiss court. And as regards that process, so they're doing it essentially for their benefit and protection. Of course, you know, we're very content for the court to issue a letter of request if that assists, but it is down to the defendants to facilitate that process and to support the order being made by the Swiss courts. It is critically important that they don't try to relitigate the question of disclosure in Switzerland by then trying to persuade the Swiss courts not to make the order sought or a narrower order. And that would abrogate their duty to this court to comply with the disclosure order that your lordship has made. So actually, properly analysed, they can get on with the disclosure process. That should be accelerated as much as possible. And when they can categorise the documents or list them, that can go into the letter of request. And when the letter of request gets to the Swiss courts, they should tell the Swiss courts that they support the order being made. And of course, it will need to be formulated in a sensible way, in a way that the Swiss court is familiar with. But certainly on our side, there's experience of having that being done and it being a smooth process. In our experience, these things always take a little bit longer than one might hope. And that is a reason, I think, to get on with all of this, because the letter of request ultimately needs to get out the door so that the Swiss courts then have time to consider the file and make the order that we are asking them to make. So, my lord, that still deals with the Swiss restrictions. There was a suggestion in correspondence yesterday, and my learned friend also said it orally, that Mr. Muller might be giving you submissions today. Now, I'm obviously delighted that Mr. Muller is here, and I hesitate to raise points about the code of conduct, but I don't understand he's a Part 2 registered practitioner, and if he's here essentially to give evidence on Swiss law, then really the appropriate course is that the court, we should have been told about that, and we should have had the opportunity to file our own evidence, and for there then to, if necessary, to be oral evidence. Now, actually, our view is at this stage none of that is necessary, because no one's saying that there is a Bank Mail Act type problem. So my suggestion to your lordship is that we don't need to get into the niceties of Swiss law, and I don't want to deny Mr. Muller his moment in the sun, but it seems to me that there's probably another time to do that and not today. So, my lord, then just finally looking at the order that they have formulated, in essence, we just say that the order they've put forward is unnecessary and that your lordship's order already made is sufficient. Now, their order can be found, I think we won't look at my composite order because it's just a bit too colourful.
It's paragraph 11 in your composite order.
Yeah, no, I'm grateful to my learned friend. I'd like to look at her order just simply because my one's quite complicated because the cross-referencing is slightly gone out of whack with all the composite elements to it. So if we look at her order, which is at 1768, it's a bit easier to follow. And I think what she's done, actually, I'm not sure what the track shows, but that doesn't really matter for my own purposes. I just want to take you through the order that they are articulating. So paragraph 13 is the order for standard disclosure. And that's something your lordship has actually already ordered. So we don't actually need to have that order again. But what this paragraph also does is give a date for compliance, which has not yet been ordered. That paragraph 4, sorry, my lord, do you have that?
Yeah.
And then paragraph 14, my learned friend is articulating this order, and she asks you to make the order that in the case of documents subject to the letters rogatory process, compliance with paragraph 9 of this order, any directions received at the September CMC shall be deemed compliance with paragraph 13. So she's saying that paragraph 9, if they comply with paragraph 9, that is deemed compliance with standard disclosure. And then if we look at paragraph 9, if you can just go back and have a look at that, that says that involves 3 steps. The defendant and claimant shall work together to 1, agree to the applicable disclosure process under Swiss law, 2, identify documents to be requested, and 3, prepare the draft letter rogatory. And then they have to submit that to the registry. So if those steps are completed, they then get a free pass on standard disclosure and they're deemed to comply. And we say that just isn't what Bank Mail Act requires. It's just not necessary. They should just go and do standard disclosure. They can get on with the letters rogatory process, and they will have to support the order being made in Switzerland. I mean, the thing that we're most concerned about is that they get your lordship to sign up to paragraph 9, and then they appear in Switzerland arguing before the Swiss courts that it really ought not to make the order because of a whole load of concerns about Swiss sovereignty. And that, that would simply be a delegation of your lordship's jurisdictional disclosure to the Swiss courts, and it would not be appropriate. So my lord, we just say stick with standard disclosure for now. can I just say that on Bank Mellet, we have given them a lot of time. I know your lordship doesn't want to go over the history, but we wrote them some time ago to say if you're going to raise these sorts of Bank Mellet points as a matter of foreign law, that you need to identify them clearly. And I say that because I have had bruising experience from other litigation where a defendant essentially drip-fed Bank Mellet points over the course of litigation, over the course of about 2 or plus years. They would say, oh, I'm terribly sorry, I can't give this. I've just found another foreign restriction that prevents me from doing it. And every time we would then have to have essentially a trial on whether there was a real risk of prosecution on that particular point. And as you can imagine, it's very disruptive for the litigation, but also you do end up then just being buttressed against trial. A few of these points coming out in the woodwork late in the day, and by the time you've sent them off for a summary determination, you've lost 5-6 months. And then you get to the point where trial is around the corner and they say, oh, well, I'm terribly sorry, it's now too late for me to do the disclosure searches, so you're stuck with what I've done. So we don't want your lordship to fall for that one. If they have Bank Mellet points, they should identify them today. They have known for weeks that we were calling them out on this. And if they don't identify them today, and your lordship doesn't then have an opportunity to give directions for them to be determined, and they come up later, we will be saying that should be weighed into the balance when your lordship looks at balancing the various interests. We will say the late raising of a Bank Mellet style point was a factor to be weighed against them. So, my lord, those are my submissions on this Swiss law point.
So let me just see what it is you're asking for in your draft order.
Yes. So if we go to 1779. So actually, I'm sorry. Let me just get my learned the orders that my learned friends inputted on. Sorry, what was the page number for that?
1768 we were looking at.
Well, actually, I was going to. Sorry, my lord. My learned friend mentioned at the beginning there was an updated composite order, and I was just going to see if I can find. Don't know if I still don't think I have that. Sorry, my lord. Sorry, I'm sorry. Would you give me a moment? My genius is going to email it to me. I might as well work from that because this is an area where I think my learned friends have made a concession.
Your Honor, might I suggest that we take 5 minutes to refresh ourselves while Mr. Shuji organizes himself?
I'm so sorry. I'm sorry for wasting your lordship and my learned friend's time. I have found it, but I'm in your hands. But we have been going a while.
Well, just give me the cost reference and then we'll take a break. Yeah.
Yeah. So it's page 2568. Sorry, my lord. No, it's sorry. 2568, paragraph 18. So you've already made the standard disclosure order. That was paragraph 11 of your April order, and all we say is that there should be a date for compliance, and that you don't need to make any other provision about the letters rogatory. That you have already ordered that they provide a draft letters rogatory, and you ordered that actually in the April hearing. And my learned friend made submissions to you about the time that she would need to put it together, and you gave them about 4 weeks. And then what we got was a download from the Hague Convention website, which was blank and not populated template at all, which we didn't find overly helpful. I mean, I'm in my learned friend's hands as to how long it's going to take them to come up with a sensible draft where they've had a decent stab at filling in the categories. I appreciate to some extent that spelling out the contents will be driven by their standard disclosure exercise. And it may be that they want to do this in stages. And the first stage is actually to give us that without that bit populated. But we think it is a good idea to get this draft up and running. And I would be arguing for us getting that. I mean, that draft has to be lodged well in advance of the standard disclosure deadline of November, if they're going to have a chance of getting an order from the Swiss courts before that point. But
it all depends, doesn't it? All depends how specific it has to be, doesn't it?
It does. I mean, our understanding is it doesn't need to be that specific, but to some extent it may be that if they want to just get on with their exercise and come up with a more specific list, then that is also helpful. So we're quite open-minded about this, but what I'm concerned about with their order is it envisages, it doesn't even envisages that the letters rogatory won't even be finalised and submitted till sometime in the autumn. And that's a real problem, because then what will happen is disclosure will be piecemeal. They'll say they don't want to give the letters rogatory disclosure, and in the meantime everyone will be working on witness statements without having seen a decent chunk of the disclosure. So disclosure really does have to happen to one milestone, and I'm afraid the ball is in their court. But the ball is in their court because they want us to go through this process so that they can sleep easy, and so that's an incentive for them really to accelerate it.
All right, well, let's take a 5-minute break now. Had you finished that submission, Mr. Shivji?
Yes, I had, my lord.
Mrs. Martin.
Thank you, Your Honor. I'm going to dovetail, or rather bookend my submissions by starting and ending saying we wish to be cooperative. We intend to support the process. This is the reason that we have put this process forward, but we can't counsel our clients to break the criminal law in Switzerland in order to do that. So first, I reject the suggestion that any of this comes as a surprise or that any of it is belated on our part. And I would turn the court's attention to the October hearing, page 827 of the bundle. And starting with Your Honor's comments at the top, near the top of the page, it says, if there is going to be Swiss law relied on and there is going to be a dispute about it, then I shall have evidence of Swiss law. That will have to come from qualified Swiss lawyers by way of witness statement. And I suppose, if worst comes to worst, even cross-examination. I hope not. Ms. Martin, you hear the point. This has got to be properly investigated. I confirmed. You went on. The Swiss law properly sorted out and explained. I am not going to require you to produce a Swiss lawyer's witness statement at this stage, but your explanation must be full and be based on Swiss law advice. You have that readily to hand because you have Lenz and Stahlen on board already. They can set it out in an opinion or whatever. So Mr. Shivji did not thereafter object that Lenz would be insufficiently independent to address this issue. And in any event, the Talim case, which is in the bundle at page 2414, if the court wants to refer to it, says that independent expert advice is not required at the case management stage. Then in the May hearing, and I would turn the court's attention to page 1540 of the bundle. That's right. Apologies, I'll read it into the record and then I'll make sure that we have the right page citation. But in any event, this exchange was a couple of weeks ago, where I stated that the suggestion that we intend to put forward to Mr. Shivji's clients is that the Swiss lawyers engage with each other and come up with a protocol that the parties agree on. It is our intention to seek agreement, but we think that all the parties should be very realistic about what is likely to come out of that process. The court responded, certainly Swiss lawyers need to be engaged to look at the realities of the situation. Heaven help us, but evidence from Swiss lawyers in witness statements as to what the law does and does not allow. You know, if this is what is going to happen, then the hearing must be properly prepared for it, and the material must be before the court so I can make a decision. This was the basis on which we submitted this witness statement. As for why we submitted it on Wednesday, it was actually the claimant's suggestion that evidence be submitted on Wednesday. Now, this was following a reference by us in correspondence to our intention to submit skeletons pursuant to the order that had been laid down by the registry, which the claimant seemed utterly surprised by. And they asked if we would agree to adjourn the date for skeletons until Friday so that evidence could be accommodated on Wednesday. So where we had intended to comply with the registry's original orders, we made accommodations for the claimants according to the schedule that they asked for. So I would reject the suggestion that any of this should come as a surprise. In terms of Mr. Mueller's availability for cross-examination, the claimants can't contest that it was necessary for Mr. Mueller to go seek permission from the Swiss authorities to make himself available for cross-examination in a foreign court. And the reason they can't contest it is because their own expert went through the same process in the autumn in relation to the Swiss testimony that was offered there. That was a process that we actually asked if they wanted us to accommodate for them, which we did accommodate for them. And so all of this is us trying to do the things by the book. Mr. Mueller here is just here to be helpful to the court, answer any questions that the court may have. If in the event that his witness statement is not clear in the mind of the court about how it applies in practice, which I can understand, it's quite dense to get through, and we've put a lot of thought into trying to make this work in this order. In terms of the real risk of prosecution, the witness statement self-evidently points it out, where it discusses that there was a case 4 years ago in which that had the effect of changing the majority view on what the prohibitions are, specifically when it comes to something like transport of documents across foreign soil. The defendant was prosecuted for putting documents subject to confidentiality restrictions on a USB stick and flying out of the country and handing them over to the DOJ. That is, I believe, paragraph 9 of the witness statement, which is found at paragraph 9 is found on page 495 of the bundle. Now, yeah. all of this can be accommodated. None of this is us saying that we aren't going to participate fully in these proceedings or that disclosure can't be handled. All we ask for is an order that accommodates the processes necessary to allow our clients to comply both with the DIFC order and with Swiss law, criminal law and the other laws that are sort of baked into the criminal effects. Now, we know that Mr. Shivji is very familiar with these protocols because, again, at the May hearing on page 1542 of the bundle, he quite fluidly rattled off what happens in these situations. And he says that you run a standard disclosure exercise so that you can identify the list of documents that are responsive, and then the application is made to the Swiss courts under the Hague Convention, identifies the material that has already been found as part of the search. So it is not some roving order where the Swiss court simply makes non-specific generalized order. The exercise is done, and then they just get validation through the Swiss courts to produce the documents. So we do not see that as a barrier. We agree, but it takes time and it takes compliance. And the compliance requires, as I understand it, a high degree of specificity. there are certain circumstances in which you can order categories of documents, maybe all board minutes for a certain period of time or something along those lines. But the advice that we've received, which Mr. Mueller is very happy to address the court directly on, is that something like all emails between X custodian and Y custodian between a certain date range that are considered relevant to the proceedings won't fly. The Swiss courts will not order that. We need to be more specific, so we have to run our disclosure exercise first. This is the reason that what we believed was compliance with the court's order on the subject, we provided a template. I wish I had used the word template in that hearing. I did not. I did say draft, but I did also say that we wouldn't have enough information to make a draft meaningful. So we intended to comply by providing that, but we haven't run the disclosure exercise. We haven't even agreed custodians. We're still talking about date ranges. Of course, we're not going to be in a position to put down any sort of meaningful lists of documents either several weeks ago or a couple of weeks from now in June. So I would ask the court to reject out of hand the suggestion that that should be done. It might make sense if the court has any questions at this time about the content of the advice for Mr. Mueller to make himself available. If not, I'll give my other remarks.
You carry on, thank you.
So we agree. We can run the search. We can run the whole disclosure exercise in Switzerland. And there's likely a lot of information that the court can freely dispose of, which is the legal test that can come through regular disclosure. And we are very happy to accommodate that. We will provide that directly. But any documents that are subject to the confidentiality restrictions that are made criminal under the Swiss Criminal Code and Switzerland's own view of its sovereignty restrictions, we have to comply with the procedures, and those procedures are that they come through a letter rogatory, and we have to give ourselves time to do that. Now, we didn't suggest that we wait until November when the parties agreed that we would conclude the disclosure exercise. We're sitting in June. Again, we don't really have the basics to run the disclosure exercise as we sit here, so we tried to come up with a middle ground, and the middle ground suggestion in terms of documents was that we provide as complete as possible of a draft letter rogatory 5 days in advance of the next CMC, which is agreed by the parties should take place at some point in September. We are absolutely prepared to comply with that date. What we cannot guarantee, however, is that the Swiss courts, whether we support it or not, will authorize the disclosure of those documents and that they will come back through the rogatory channels by the 8th of November. We simply don't have control over those processes. And unfortunately, where we're sitting here in the UAE that doesn't have a treaty with Switzerland, it's going to be slower than if the Hague Convention were in place. Those are diplomatic choices made by the UAE and factors outside of our control. And I would strenuously ask that my clients not be put on the hook or risk non-compliance with any order because of any delay through the diplomatic channels. And just to bring the court's attention to what we did propose, it is in paragraph 11 of, I believe this is the composite order that was put together with the areas of agreement and disagreement, and that can be found on page 1782 of the bundle.
Yeah.
It proposes a collaborative process because we think it's the only way that this works. Again, what we don't want is to go away, be solely responsible for the process, go do the process, put it into motion, and then have the claimants come back not having objected at any point throughout there or contributed and say that we didn't do it right and that there should be inferences held against us as a result. We want to do it once. We want to do it right. If it needs to be done in multiple tranches, we can do it that way. But we simply just want a process that works under the legal requirements. Those are my submissions on this topic.
Right. Anything you want to say, Mr. Shivji?
No, my lord. I mean, it's just to say, actually, sorry, at one point, it is their standard disclosure obligation under DIFC law, so they need to get this order if that's what they want to do. And I don't really understand the final submission from my learned friend that we would somehow criticise them. They're only going to be exposed to criticism if the process doesn't work and they don't get the material. There is no reason as a matter of principle why they can't get the order and disclose this material. So it really is their responsibility. But and they obviously can keep us informed and keep the court informed. But it is on them to scale this particular hillock themselves, and we don't see why we have to be heavily involved in the process. They can take their own Swiss law advice as to the way they can do it most successfully. And the issue of this lettuce regulatory doesn't need to wait till September. I mean, that's 3 months away. Why can't they crack on with it now and get it in shape so that they can get it to your lordship in good time? And if need be, if your lordship's willing to consider an issue on paper, then it can be sent off well ahead of the November milestone, and that would be our strong preference.
Well, I think we need to set up a timetable of some kind in order to get this process moving. And what I envisage happening is that obviously the various searches are going to need to be carried out to see what documents exist, but the categories of documents must be relatively plain. And the question is whether or not letters rogatory can be issued which are sufficiently specific for Swiss court purposes by reference to categories of documents or not. That's the first question, and what I would suggest is that Mrs. Martin makes the first call on that and then produces a draft to the claimants, who can take Swiss law advice and see where you get to. But if it has to be done in tranches, then do it in tranches. Get as much done as early as possible. But obviously, there's no point in making applications which are known to be likely to fail. I mean, that's obvious. But I don't see any reason why we can't get things moving generally in relation to disclosure and be doing this at the same time. So where are we currently with regard to timetabling of any of the disclosure obligations?
On our view, they didn't really engage with the Swiss obligations, and so the only timetable that has been proposed has been ours.
It's not entirely fair. What your lordship ordered at the April hearing that they produced the draft letters regulatory, yes. And we haven't had that. We had the template.
No,
that was downloaded.
I understand that.
So that is the first step.
In a sense, the two processes go together in working out what documents there are.
Yes.
In the first place.
Yeah.
And then producing the letters rogatory in order to get permission. But where are we with regard to timetabling on disclosure generally, without regard to the letters rogatory?
So I think certainly not as far advanced as we were hoping, because we were really hoping that at this hearing, all of the disclosure proposals really could have been formulated, that is custodians and date ranges. And I think in light of the lack of information about what was going on the defendant's side, we just haven't had that. We haven't been able to identify the personnel because they didn't want to tell us, and so we haven't had an opportunity then to talk to them about custodians and date ranges. I mean, what I did have some sympathy with Miss Martin's submission earlier, that actually it's often very productive to get the solicitors into a meeting together, where they have to try and hammer out an agreement on these things, and it's actually often quite helpful if that is done on an open basis as well, so that the court gets a minute of what's happened. And so if there is obstinacy on one side, it's clear to your lordship that someone's not playing ball. But I in terms of where your lordship goes from now, they're going to be ordered, I hope, to provide that information at paragraph 4 of our order, and that will educate us as to the identity of potential custodians. And then it seems to us that we need to have a discussion inter partes to pin down that list of custodians, at least on a 95% there basis, and also to agree the date ranges. And I think we're agreed on both sides that the date ranges need to be tailored to the individual. You just don't need to have blanket date ranges for everybody. And if you can be sophisticated in crafting the date ranges, it very substantially reduces the burden. So I think, my lord, that probably is the thing that needs to happen next. It is contingent on getting responses to the information we asked for, and then they can get on with their searches. But in the meantime, Miss Martin might be able to have a decent stab at the categories. But I think all with a view to her probably producing another draft, a proper draft of the letters rogatory, I would say before the summer vacation, with a view to getting it to your lordship for consideration, subject to your lordship's diary, around then.
I would suggest
that I had anticipated, when I made an order on the 19th of April, saying the date for compliance will be determined for disclosure at the hearing on the 10th of June, that by the time we got here, the parties would have sorted out custodians, keyword search terms, categories of documents, and so on and so forth. And we're really very little further forward in that respect. So it seems to me what I need to do now is to provide not only for a meeting, but dates by which there will be agreement on custodians, search terms, and categories of documents, failing which the matter will have to come back before me either on paper or for a further hearing, and for the draft letters rogatory, what have you, to be fitted into that timetable as appropriate, with a view to everything being done so far as it's possible to be done by November, and a CMC or two fixed to make sure that progress is being made in that direction. Now,
may I make a suggestion that I think will help accelerate that? First, I think that we already have a long list of, we've provided a long list of custodians that we are happy to work off of. On some of their suggestions, we have conceded, and so we're happy to bolt that on. I think there are disputes about some of the others, so I would suggest that in terms of date ranges and search terms and any other negotiation that needs to go on with regard to the agreed collection of custodians, that doesn't need to wait. I would ask the court to put the parties in a room as quickly as possible on those. In terms of the other exercise that the court seems inclined to ask us to run with regard to organizational structures and that type of thing, that's a process that can be bolted on, I think, at a later stage just to keep things going. But I do want to point out, just to be fair to what it is that we've proposed, at page 1767 of the bundle, paragraph 7, which is I think this is our red line versus what their original order provided. We propose the parties shall exchange preliminary lists of keywords and specific date ranges in respect of each custodian by 4 p.m. on 1 July 2024. Let's assume maybe we can even accelerate that. I don't know, but that's what we proposed then. That's what we thought was realistic. The parties shall discuss the preliminary lists of keywords and specific date ranges for each custodian with an aim to agreeing the same by 4 p.m. on 15 July 2024. So what the court is contemplating now is exactly what we put forward and which was explicitly rejected by the claimants. So where I think Mr. Shivji rather seems to be saying that if one party is being recalcitrant and with the suggestion that it must be us, I would propose that we are putting forward very realistic, very, I think, pragmatic solutions that the court should be looking at whether it should adopt.
Mara, can I just come back on that? I think I very much encourage the idea of getting together and trying to hammer out a list on keywords, date ranges, and custodians. It needs to happen together. What I don't want to go too much into the history, but the first engagement we had on our questions about custodians was a letter last night, where I got a 10-page appendix from my learned friends setting out their positions on custodians for the first time. And of course, the areas where they're resisting custodians are the areas that we're most interested in. But because they sent it to me on Sunday night on the hearing before a Monday morning hearing, I haven't had a chance to put in evidence or submissions to Lordship on why we want those custodians and why you ought to order them. But this needs to be done as one composite exercise where the collections are done together if possible. And there is an interaction between keywords, date ranges, etc. So, I mean, my suggestion would be that the parties don't bifurcate the process, but do require the parties now to reach a landing quick, smart on custodians, date ranges, and keywords. And if they can't, then we will need to come back before you. And I'm sort of regressive. It's regrettable that we are in that word, because like you, I was expecting the CMC to do that, but we just haven't. I mean, without going into the history, we're just not in a position where we have the information to make those sorts of positions. And frankly, if it hadn't been for this hearing being the diary, I doubt we would have even got the letter last night.
If I could correct myself, actually, apparently what I just read out was agreed in paragraph 9 of the draft composite order. So this is something that the parties have already agreed.
Yeah, I've got it in paragraph 9 and looking at that.
Again, the letter that we provided last night was proposed to us on the 4th of June. 5 days is timely to put together a 20-page letter.
Let's not go back over history. I'm looking now at paragraph 5 onwards of what I understand to be the composite draft, which I think is at page 1780 or thereabouts. 17, yeah, something like that.
Yeah, those are agreed. Those were agreed earlier today.
So paragraphs 5 and 6 are agreed, right? Claimants, custodians to be searched shall include the individual stated in Appendix 1, defendants in Appendix 2. That much is clear, is it? And agreed. Now
The appendices are currently empty.
Right. Okay, but we have. But do we have some who are agreed? We have 27 or something who have agreed.
We have some that are agreed. There are quite a few that are not agreed.
No.
But
let's have a list of what's agreed to start off with.
Yes. Okay.
Okay. Then paragraph 7, as was, defendants begin a final extension to comply with paragraph 8 of the April order. Which is that?
That's the letters rogatory. It was the draft letters rogatory. So that was your lordship had ordered them to provide the draft. They got the template. Right. I mean, we had in mind that they should have another stab at him.
24th of June. Well, let's leave that to one side for the moment. Then we've dealt with the lists of clients. So I think the next thing to do is to fix a meeting. Do we want to actually fix a date now, or shall I say within 7 days, or what?
Could you say with it? I think to avoid having to consult everyone's diaries, I think if your lordship could just say that it takes place within 7 days. Someone will message me if they say that's impossible, but I think within 7 days is a good idea.
If it's going to be in Dubai, it needs to be this week for me. If London is possible, I can do next week.
My lord, there is the question. There is the question of these identity of these individuals that we were. I mean, that is what held up the custodian debate. So we deferred the question of when the claimants were going to provide that information, but I mean, in an ideal world, they'd provide that before the meeting, and then we could just have one meeting to talk about it all. So I think the ball is in my learned friend's court on that.
Yes. So when can you produce the list of names? I think that is necessary. I mean, I want this meeting to take place, at which there will be discussion of custodians and search terms, and hopefully agreement and date range, so that all of this gets ironed out. If it takes you all day to do it, well, it takes you all day to do it. But that's what I was hoping for. So it does need, in advance of that, there to be identification of the various structures and individuals and organizations concerned, so that there can be a sensible meeting of minds at the meeting.
I think that we can substantially comply with the paragraph 4 requirements, but I'm concerned about something like the compliance person responsible over a period of time. I think that's going to take some time to put together, and I can't promise to have a complete answer to a question like that, but within a short period of time.
Oh, well, it's Monday today, isn't it? Can we say Friday for all these bits and pieces, and if there are bits you can't do, well, so be it. But let's provide for Friday. And then if there's going to be a meeting next week, where are you going to be, Mrs. Martin, next week?
I'll be in London and available on definitely Monday, Tuesday, I think Wednesday as well. I'm completely out of pocket Thursday, Friday.
It's a very odd expression to me, out of pocket. In English terms, that means you haven't got any money.
Oh, I might be that as well, but unavailable.
What's the origin of the expression out of pocket meaning unavailable?
That is an excellent question, and I will come back to the next hearing with an answer.
All
I don't know.
I mean, I've always understood out of pocket in terms of money as being rather obvious. I've got no money in my pocket. But anyway, there we are. Okay. Monday, Tuesday. Does it make sense to have this meeting in London, in fact, Mr. Shivji?
I don't think so, actually, because I think we would want our Dubai team involved, and my London team will. I mean, my junior might join. The Dubai team are just remind me that it's Eid next Monday or Tuesday, right. So that is a slight wrinkle. I mean, I just wonder, I know your lordship wants to get on with it, but maybe as soon as Miss Martin is back in pocket, if that's the right expression, we should have it then.
Well, when are you going to be back in Dubai, Mrs. Martin?
I can be back the following week. It's not currently in the travel plans, but I can make it happen.
But we're not messing around with anything that's too critical for you.
The more critical things are a couple of weeks after that, where I'll be in the US. So I'd rather come back to Dubai for the meeting and
okay.
Accommodate those.
All right. Well, let's. What about Monday week then for meeting? And those who aren't in Dubai can attend by Zoom or whatever. So we've got paragraph 4 by Friday the. What are we? 9th today?
Yeah, 14th. Friday the 14th.
14th, is it? Right. Thank you.
Today's the 10th. That's right.
Thank you. So it is. Meeting then on Monday the 24th.
Yes.
Can I just let, after looking at flights and that type of thing, in case it's impossible to get back, because I won't be able to leave until the 11 p.m. flight, and in case that's fully booked, it just might push things by a day.
Monday 24th, Tuesday 25th, to be agreed. At which everything will be discussed in the context of disclosure. Categories of documents and the extent to which those can form part of letters rogatory, custodians, search terms, date range. And then let's just see where we are. Then, supposing you were then to produce letters rogatory of such defined categories as were capable of being agreed, when would you be able to do that, Mrs. Martin, if you're having a meeting on the 24th or 25th?
So I hinted at this earlier, but my one constraint is that I really believe I have an unavailability to take client instructions between the 20th of June and 8th of July.
Yeah.
I don't know what days of the week those are.
20th of June is a Thursday. 8th of July is Friday. No, it's not. It's Sunday. Monday.
Could we have to the end of that week so that I have an opportunity to run whatever it is we've come up with by the client and Swiss Council?
5th July.
12th.
The 12th July. Well, that's most of this will be a discussion with Swiss Council, I would think, won't it? As to what the form of the letters rogatory will be.
Well, I have to make sure that my apologies.
No, you carry on.
Well, just where we won't have had the opportunity yet to go in necessarily. I mean, we'll get a start on it, but I'm just not sure we'll have an opportunity to go into a database to say these documents necessarily exist. I want to make sure what it is that we're putting before the court is, again, reflective of reality.
And how long does Mr. Muller think a Swiss court will take to deal with letters rogatory? I don't think he says that in his witness statement, does he?
No, I don't think he does, but my understanding is it's quick on the Swiss side. It's the UAE that tends to be a bit slow on the delivery of the letter.
And how do we exert pressure on the UAE diplomatic forces?
I wish I had that kind of wasta. Perhaps, I don't know if the claimants have any suggestions.
I'm afraid I don't. I mean, I think I don't know enough about that process on the UAE side, I'm afraid. But I think it's just I think we just need to initiate it as soon as possible. I mean, that's the answer to start earlier.
Well, it may be possible to get the Chief Justice to write a letter or something to the minister or whatever it is.
In my experience, documents sort of get lost between MOFA and the Ministry of Justice, and both of them point at the other one when processes fail. So I think it's a process of engaging both of those ministries.
Sorry, that's the Ministry of Justice and the Foreign Affairs?
Correct.
Yeah. Okay, well, I have to do your best. I mean, I think my influence would be minimal, but that of the Chief Justice or the Deputy Chief Justice, probably the Deputy Chief Justice, who's got his finger on the pulse, is the man to seek to involve in this, if at all possible.
Shall we do that through the registry, or will Your Honor take care of that?
I think it would be best if you talk to the registry, go to the top of the registry and get her to talk to the Deputy Chief Justice. Anyway, that brings us back to dates. If we're having the meeting on Monday the 24th and Tuesday the 25th, draft letters rogatory by when?
So we had said we had asked for the 12th.
Now, does it make sense to try and build in a further CMC before then, or immediately after then?
I think immediately after.
Can always be cancelled, of course, if it's not needed. What's your thinking about that?
I would think immediately after.
So that's 2 and a bit weeks. 2 weeks, or what do we know? 3 weeks nearly after your meeting, which should have given plenty of opportunity to agree on all the details.
My Lord, just
begin the searches and make significant progress as to what there is to disclose. Yes, Mr. Shivji, you wanted to say something?
My Lord, I apologise. I'm just looking at my diary for that period, and I have At the moment, I'm not available in the weeks of the 15th and 22nd of July, but I am available in the week of the 29th of July. I don't know how that fits in with your lordship's diary.
Not very well, I think. No, I can't do anything in the week of the 29th of July.
Okay, and what about the week earlier? So I'm just looking. I'm so sorry, am I not to be doing this?
Yeah.
But just looking at the week of the 15th of July, I've got something early in the week which I could move. I'd be obviously delighted to do so. The end of the week is difficult, and the following week, the week of the 27th, is really difficult. Sorry, the week of the 22nd is really difficult for me.
Well, I'd rather like to push the 12th of July date, bring it forward, so to speak, earlier.
Yes.
Because I've got a hearing the 10th, the 12th of July. I've got a hearing 16th and 19th of July. I can do something in the week of the 22nd. Oh, yes. Well, there's a date or two on the 24th. Not much. Then there's nothing in the week of the 29th.
So my lord, I'm much better placed in early July. Like it sounds like you are as well. But I would prefer to bring it forward.
If it were possible to do what's that? It's the 8th. I think my only real possibility is the 9th of July. So is that workable for you, Mrs. Martin?
I'm actually sorry. I'm sorry, my lord. I'm on a judicial course on the 9th of July. So actually, I can't do that, unfortunately, because they won't allow me. They won't free me up. So that's doing the 9th and 10th of July. Is there anything else that week, or is you otherwise full that week, my lord?
Well, the only thing I could do is an early morning thing because I'm in arbitration for that week and the next week. I mean, I say if we're going to do that, it doesn't make a lot of difference to me which week it is, probably. If the week of the 15th is more suitable, I can do that, but it'll have to be an early morning hearing at UK time. Hopefully it won't be more than an hour or two. That will be only ironing out those bits that haven't been agreed and saying yes or no to particular custodians or date ranges or search terms. But you know, the reality is the parties are much better in sorting out search terms than the court's ever going to be, because they'll have much more familiarity with what really works. So the only likely disputes would be over custodians, I suspect. And I suppose the form of the letters rogatory, if there's some particular dispute, which would have to be informed by what Swiss lawyers tell me, I guess. So sometime in the week of the 15th, then?
Could I ask
Yes.
for the 17th, just based on
Wednesday?
team members, or the schedules of my various team members?
Wednesday the 17th. I fear we're going to have to make it 7 o'clock UK time, 10 o'clock.
That's fine from my perspective. And thank you, my lord, for accommodating us.
And if, when you look at it, it turns out that it's only going to be an hour or something, then consider it a more civilized time, from my perspective at least. All right. So that's Wednesday the 17th. Now, what do we need to put in place after that? Fix another date in September sometime.
Yes, please.
To be on the safe side.
I think it will be likely
For
necessary.
further arguments? Yes, well, I suspect it will. I can offer you September the 16th.
Yes, it's fine. Fine for me.
Okay, is that all right with you, Mrs. Martin?
Yes, it is. Thank you.
All right. Now, what else do we need to debate today?
So, my lord, there was the RDC 28.5 documents. This really is a short point. It ought not to cause any controversy. The RDC 28.5 is the same as the English 3114 regime, documents mentioned in a statement of case. My learned friend Skeleton spends a lot of time talking about the relevance of these materials. That's not a consideration under 28.5. There is a right to inspect where a document is mentioned. In their draft order that they sent us ahead of the CMC, they had actually agreed to produce the vast majority of these, and then we went backwards in their skeleton argument. But there's no dispute that these documents are mentioned. There's no argument to be had about relevance. So as we understand it, they ought to provide the lot. There is only two categories where a specific issue has been identified, and I just want to address you on those. The first are what are called the MIS reports, which are reports that the fourth defendant would have sent BSA during the course of the relationship, and they were required to provide them every quarter. And as far as we know, they did do that. Now, I think what's said there is that we ought to go and search our records to see if we can find them, but we cannot easily do that, and we cannot easily find them, which is why, because they've been mentioned, we want them to be given. And there can be no banking secrecy because they themselves seem to be saying that we've been provided with this in the past. And that's in my learned friend skeleton argument at paragraph 20.1, 1843. So we say they should just produce these, and we can't really see what the difficulty would be. And then there's a separate point about the legal advice given in relation to the Carafi litigation, where they seem to be trying to assert privilege. And we don't really understand that, because the defendants were joint defendants in the Carafi litigation, represented, both clients represented by Al Tamimi and co. And we can't see how they can assert privilege against a co-defendant. So we don't see actually anything in any of those points.
We're talking about advices that were given to both parties.
As I understand it, but even if advice was given to one, even if the fourth defendant was sent something by Tamimi that was specific to the part of the case against them, I don't see how that could be, a privilege could be asserted against my client, because they were just co-defendants. And it may well be that Tamimi from time to time were looking at specific parts of the case against one or the other parties. But one party isn't able to turn around to another and say, you're not allowed to know what our solicitor has said to me.
No, well, it's our solicitor point, yeah.
Yeah. So that's that's point. Sorry, there was one other point, which is that this point about the employment contracts is still kicking around. So this was Mr. Carter. This was the employment contracts which had been redacted for banking secrecy issues. I think all of that has fallen away now, and the only point taken is that the only redactions they want to maintain is the salary information. And they say that's confidential because Mr. Sassoon isn't entitled to know what Mr. Astruc's salary is, and vice versa. I mean, this point, with the greatest respect, seems like a make-weight. I mean, the salary information is important to us because we need to know how these individuals were incentivized to act. And in particular, if they were given incentives to act in BJSS's best interest. So if the metrics according to how they were remunerated was according to how the fourth defendant did, or indeed the fifth defendant, but how the fourth defendant did, then that is relevant to our case. And in any event, how they were remunerated by the fourth defendant is relevant to our case. So, and there have been various arguments that have been put out, I think, amongst banking secrecy, data protection, commercial secrets. Actually, none of that seems to be maintained in my learned friend skeleton. I think where she ends up in the skeleton is simply that you Mr. Astruct ought not to know about Mr. Sassoon and vice versa. And there's nothing in that. There's actually no genuine legal objection. And so those materials should now be presented, given to us unredacted. So, my lord, that's our submissions on those categories of documents.
On the MIS reports, the defense does mention the fact that MIS reports were sent to the first claimant. It doesn't mention any specific MIS reports. It doesn't mention any content of MIS reports. I would like more detail on what this great difficulty is the first claimant has searching for those, given that it received all of them. And I don't understand or accept the suggestion that it is somehow easier for the fourth defendant to go searching for those MIS reports. We, at this point, have no reason to believe that they are all contained in one place. And so where Mr. Shivji accepts that his client is in, or at the very least should be in possession of those documents, it is no excuse to say it's difficult and therefore we don't want to go look for them. As to the Tamimi advice, again, if it's joint advice, they should be in possession of it as well. And in terms of the Tamimi advice that was mentioned in the defenses, we have disclosed it all already. As to the salary information, he's talking about metrics and formulas and things like that. Like that, we have authorization to provide unredacted. He's shadowboxing there. The only thing that the defendants have asked remain confidential, because it is a matter of great confidentiality in Switzerland, is just the number of their salary. I've tried to come up with a court-appropriate analogy for this, but asking one defendant to be privy to the salary information of another, it's a little like asking a proper English gentleman to show up in court in his rugby kit. I mean, it just isn't done. And so what relevance can that number possibly be if they understand the mechanics of it all? We have excuse me, just 1 minute, I'm receiving a note here. The note on Swiss advice does contain all the information the court needs to find that it is consistent with Swiss law to maintain the confidentiality over that information, and without any great reason to disclose it or relevance or anything else. We don't understand the point other than for nuisance or harassment of our clients.
Milo, can I just address you on that? I mean, we're quite happy to keep the information lawyers only, as your lordship's already explained that it would be subject to the implied undertaking. But it is relevant, because if these individuals were very well remunerated for the interests of the fourth defendant, then they were in a position of conflict of interest. I mean, that is essentially our case, and they preferred the interest of one over the other. And so, if they're extremely well paid, that is relevant. But it seems, I mean, I'm all for arguments about it's not cricket, but I mean, we'll deal with this sensitively. We're not going to use it for harassment. I'm very happy to agree that it comes lawyers only, and if it needs to leave that environment, so be it. But in any event, on my side, we're a professional team. My client's even a professional, so it really, I can't see what the concern is about where it would go. And your lordship knows from other hearings that I deal with confidential information sensitively and don't mention it in open court where there's a concern. So my suggestion would be to deal with it in that way.
Right. Well, as to the reports and advice that are referred to in the pleadings, I can see no basis for not applying the relevant rule, which is if you refer to it in a pleading, then you must produce it if it's asked for. So far as the employment contracts are concerned, they should be handed over unredacted, but the salary figure should be kept simply to the lawyer's confidentiality ring and go no further. All right.
Your Honor, may I just ask that we have substantial time to comply on the MIS reports, because that's going to be an 8th of November exercise. That's not something we can do in short order.
Right. These are monthly, is that right?
They're quarterly.
No, quarterly. Quarterly. Yep. So it says quarterly. Yeah.
I mean, my sense, perhaps we can take the timing of it offline. I mean, I'm not looking to put my friend under impossible pressures. It may be that there's some of them that are easier accessible than others, and we can get it in tranches. But perhaps my lord, your lordship's dealt with the principle of it, and I think maybe the mechanics we can try and agree.
I do think we need an agreed date range on those as well, because the suggestion, at least was previously, that they need to go back to 2005. That's just not relevant. It's not possible.
We're simply looking at 2012 onwards, aren't we?
Yes, that's right. 2012 onwards is fine.
2012 onwards. Very good. That's that.
And then, so my lord, I think moving then to the next topic, I think amendments, I think we've agreed on. I think my learned friends are not pressing for their permission to amend.
Well, they'll want to amend, no doubt, but
yes, of course,
they can produce the document when they're in a position to do so and apply for permission at the time if it's not consented to.
Yes, exactly.
Yeah.
And I mean, inevitably, as a result of the disclosure process, as more information comes to light, we will likely want to amend as well. So that's just how it gets. Very good, my lord. So next point is witness statements. I hope we can tail this very shortly. We suggested the usual order of simultaneous exchange of witness statements. My learned friends seem to want sequential exchange, with the claimants going first. I mean, it may be in other jurisdictions that's a common order. In my experience in this jurisdiction, it is not. I mean, it is striking that when we were dealing with things like custodians, they were quite happy for simultaneous exchange of information, but suddenly when it comes to witness statements, it needs to be sequential. I also don't want to overpromise as to how illuminating the liquidator's witness evidence will be. Your lordship has previously mentioned this, that in these fraud cases, the case is often largely driven by the contemporaneous documents. We don't know yet at the moment who, if anyone, we will want to call and on what. But it's unlikely to be a fulsome set of witnesses, because of course we weren't there contemporaneously, and we just don't have an army of employees who are still working for us who can be involved in this litigation, and that's where we're in a different position to the defendants. So we just see no reason to have sequential exchange, and we rather feel that it's a bit of a litigation tactic. So those are my submissions on that point, my lord.
Yes, Ms. Martin.
Well, it is the claimant's burden of proof, of course, and I think that the reasons that Mr. Shivji just listed for simultaneous exchange are exactly the reasons that we rely on for sequential exchange, that they do plan to put in this broad case through no more than 3 witnesses. I mean, at least one of whom we assume would be the former or current liquidator, to give the evidence acquired during the investigation. But I mean, it will be interesting for us to see how they get their whole case in with so few witnesses, or alternatively, if there are pieces that they have to give up. And given how much of their current pleading is on the basis of inference, we think it's fair that we get to see it before we have to put in evidence on it ourselves. One of the court directions actually provided, I believe, by claimants as part of the bundle process, found it 2118. And so in their own guidance, it states that the matters within the court's discretion and considerations of good case management may, in particular situations, justify a different order. Sequential exchange may be appropriate on issues of quantum it lists there, where witnesses may be expected to assess each other's calculations. We would say that the date by which to disclose witnesses, at the very least, needs to be sequential. We, at the very least, need to know who they're putting up so that we could anticipate what it is that they might say. And I think it's also important to note that we put forward a 2-tranche proposal to accommodate any Swiss resident witnesses to maximize the amount of testimony that is not subject to Swiss law restrictions, so as to reduce the potential for the Swiss process disrupting the schedule. We would strenuously ask the court to take account of that request, which can be found starting on page 1783. The text in red, starting at paragraph 21, which has been rejected by the claimants.
Yes, anything else?
I mean, we would note that we pushed back the initial date on which witness statements are due in an effort to accommodate the Swiss process. So that's part of the reasons for the differences in the proposed dates. Just to be, apologies.
No, you go on.
And just to be clear, that we anticipate that there will be some, or maybe even the majority of information that can be freely disposed of by the Swiss witnesses, and so that could come outside of the letter rogatory process. We just want to be able to accommodate both and provide as much information as we can on a more predictable schedule, I suppose.
Well, I can't see any reason at all for sequential witness statements. There might be some different order in relation to the accountancy evidence. We'll come to that in a moment. It seems to me that witness statements ought to be exchanged. It also seems to me that the parties ought to be identifying their witnesses as soon as may be. In case management information sheets, people fight shy of it, but I don't see any reason why people shouldn't identify the witnesses. They're not committing themselves to call them. They're just indicating who might be called, so the other side has some idea of the areas in question. Whether the liquidator can produce anybody who's going to be able to give contemporary evidence is another question, but they'll have to decide that. I would favour a notification date that is a couple of months in advance of the actual service of simultaneous witness statement, so that there is some opportunity for people to think about what they need to include in theirs. But the case will be pleaded, and I'm quite sure there'll be amendments to pleadings if the disclosure is of any benefit, or the claimant thinks it's of any benefit to itself. And being an English pleading, effectively it ought to set out the full particulars of the fraud that's alleged. So it's not as if you're going to be taken by surprise, Mrs. Martin, as to what the case is that's being made against you. So your witness should be able to deal with it. And in essence, we all know what the case is, and we all know what your defence is. So I can't see a problem in you producing witness statements. So simultaneous it is, and the only question then is date. What are you suggesting at present? February, both of you?
So we're suggesting March, my lord. And the thinking for that is that if insofar as my learned friend wants to get any letters rogatory, she's got loads of time. She's got 9 months to do it, and she can do that on a broader basis if she wants to get permission to call a broader group of people.
It'd be more like 6 months, won't it, to do it?
Yes.
By the time we've got disclosure organised, yes. But yes.
So she'll have plenty of time to. Sorry, I say sorry, my lord.
But we can even afford to push that date back a bit if need be. So, but let's leave it at March, and it's a liberty to apply. If there's going to be a problem, we can push it back a bit. We've got a trial date in October, so that's not a terrible problem.
And there's no need, we say, for any of the red machinery that my learned friend said. We don't need to have this bifurcated process where there's.
Well, I think not at this stage. Not at this stage, and if it becomes necessary at a later stage, then we can always revisit that.
Yes,
but
agreed. And
let's try and keep it simple so that there are no more stages in the proceedings than we need, and hope that the letters rogatory situation sorts itself out.
Yes, agreed. And my lord, just to pick up on my learned friend's submission about whether we would have the witnesses in order to advance all the evidence in our case. I mean, I just flagged to her that there is a difference, quite a significant difference here between US civil practice and the DIFC civil practice, in that we do not need to lead evidence through witnesses of our entire case. And I know in US trials that there's a lot of time is spent calling witnesses so that you can advance each cornerstone of your case, whereas in a DIFC trial you don't need to do that, and we could bring an entirely document-based case and not call any witnesses at all. So my learned friend needs to decide what witnesses she wants to call according to the pleaded case that I have advanced and I will advance, rather than what she anticipates I decide to cover off through my witnesses.
And a provision for Civil Evidence Act notices is what date have you put that in?
Same date as witness statements, my lord.
Yeah, exactly right. Right. Okay, and are we providing for supplementary witness statements or not?
We haven't. I mean, it depends on the case. I mean, my experience is that it's not always useful, and also sometimes, I know no discourtesy to anybody, but sometimes parties are tempted to hold evidence back, which is really unhelpful. So, I mean, our sense is that there should just be one round, and that's what we provided for.
Well, I'm going to provide for liberty to apply in relation to reply witness statements, just in case there is something that either your Civil Evidence Act notices deal with points that Mrs. Martin has not been able to anticipate, and therefore wants a witness to be able to speak to a particular document that you rely on. So there'd be liberty to apply in relation to supplementary witness statements, which I always order should be short, and nobody ever takes any notice of them.
Well, it's helpful. It's noted, my lord, and we agree. So thank you.
I have yet to have someone apply and say you ordered short witness statements and this one's a long one, so will you therefore strike it out? Yeah. But there will always be a first time.
Let's hope this case is not it. So my lord, moving on to experts.
Yes.
I mean, actually, there's a broad measure of agreement between us. There's only this question. My learned friends want to have an additional field of expert evidence on banking mergers and acquisitions. I mean, as I understand the logic of their position, they say that it may not have been able to sell this business at all. And so that's why they want this other field of expertise. But I mean, to our mind, it just falls within the quantification question. I mean, their quantification point is essentially it's zero. It's worthless. And they can make that quantification point within their valuation evidence, because they will need an expert who will be experts in these sorts of transactions as well. So I don't see it as a different field. And also I would suggest that if your lordship is minded to go with us for the time being on the fields that we propose, there is scope for the parties to come back later to do two things. One is I think the parties should flesh out a list of issues for the experts, because it is really unhelpful otherwise to have very broad ranging expert reports that are diffuse and unhelpful for your lordship. And secondly, that it is open once the parties get into the expert process. If they suddenly think, oh my goodness, there is a different field here, it is different in nature, our expert can't deal with it, then there's obviously scope to come back to your lordship to ask for it then. So my sense is, subject to your lordship's view, is that one ought not to dwell on this at the moment. The two fields we've identified are probably good enough for present purposes, and we'll come back later with lists of issues and, if necessary, arguments about any additional field. So those are my submissions on that.
I see some purpose served in the valuation experts meeting in advance of any reports, with a view to saying what documentation they need in order to carry out their valuation. Very often one discovers that there's an issue when an expert produces a report and says, but I haven't seen X, Y, and Z. Whereas if we provide for them to meet and determine what documents they need to see for the purposes of their reports, I think that would be a real plus. But in terms of the particular expertise of the valuation of the business, what is the expertise in question that we're looking at here?
So to our mind, I mean, a valuation, I think a valuation expert would be able to cover this. I mean, I've got a lot of valuation disputes, and my experience of it is that these valuation experts cover a range of different industries. I mean, there's a few that one always tends to encounter, like financial services businesses and oil and gas, and certain areas that they seem to attract competition disputes sometimes. But they're very good at picking up a range of industries, and this is really, to our mind, pretty standard. It's a financial services business with a client base and assets under management. So I don't think they need any specific valuation expertise, but I would anticipate that a valuer of that nature will be able to tell you if the business is worthless, which is really my learned friend's point.
Well, you're envisaging one of the usual range of forensic accountants who put themselves forward as having expertise in all sorts of areas where they just stick a finger. Well,
I started life as a banker, so I've got some sympathy with what they do, but yes, they do. That's what I had in mind. One of the, as you say, it tends to be the big accounting firms, but there are organisations like FTI and other expert bodies who do this very well as well.
Yes, all right.
So, my lord, I've got nothing further to say on that. I don't know if my learned friend.
The Swiss lawyers, as and when we have a list of agreed issues, they will be able to formulate their reports on the basis of the list of issues.
I think it would be worth actually the parties trying to agree a list of expert issues. So that might be easier, because actually, ultimately the Swiss experts need to be given a menu, and it is far better if that is confined, because otherwise it runs off. These reports run off into the hundreds of pages, and it doesn't actually illuminate the question. These are very short, narrow points.
I agree. What I envisaged in the list of issues was a list of Swiss law issues. Right, Mrs. Martin, what do you want to say about the points that have been raised so far, and then your request for an additional expert?
Sure. Well, having been involved in the sale of 3 Swiss banks, I can tell you that banking M&A is a cottage industry. It's not something that I would suggest should be covered off by a generalist, as it sounds like Mr. Shivji may be willing to use. The duty to sell BSA or its assets is a core allegation. We can see that in the particulars, paragraph 110, 115, 121. I can I know the court's familiar, but
BSA isn't a bank.
Correct. You're right. But it is an asset management, not asset management. Let me take that back. It is, it is a financial services advisor who really only had a custodial relationship with one bank.
Yes.
And there are very specific effects on the business relationship as a result of that arrangement. And those affect whether or not this could be sold. And we do, here's the problem. We could probably line up somebody from the client to say this couldn't have been done for these reasons, but Mr. Shivji is going to come back and say this person's biased. Of course they're saying that. So we do think it would be of assistance to the court to have somebody independent assess the contractual relationship, the functional relationship, and say whether or not it was possible for a sale to take place under these circumstances. Now, could we probably find someone who could do both quantum and that piece of it? Sure, but what I don't want to lose is the scope to have an independent person answer these questions. If Mr. Shivji doesn't want to answer them himself, that's fine, that's his choice. I don't think he needs to go out and hire one just because we do if he's not interested, but where it is a core element of the allegations that there was a duty to do this thing, and it is a core element of our defenses that we say, actually, it was really impossible under the circumstances, we would suggest that it is either necessary or at the very least would be helpful to the court. This is like banking M&A is certainly a recognized discipline. If you go on the expert shops, they list M&A experts with sectoral specialization in banking.
My problem with is this, Mrs. Martin, you're going to produce fact witness evidence, at least I assume you will, from the directors and so on, who said that we thought about a sale and decided it was quite impossible. So you're going to have fact evidence to show that a sale wasn't on. But when it then comes to an expert in the area, I mean, who really is an expert? It's like many of these, it's not really a banking question at all. You say this was a tied customer, effectively, in the sense that he's an advisor who only had one custodian that he could use for advising his clients to make contact with and borrow money from, to invest and so on and so forth. But that doesn't seem to be a banking or merger expert at all. It's someone who's in the financial asset investment advice area. As I say, whether it's someone who has a bit more down to earth on the ground experience of that than the average forensic accountants who offer opinions on all sorts of interests, I don't know, but it isn't really a banking and mergers person, is it?
Well, I would suggest that the figures that Mr. Shivji has used to say how much he considers or his team considers that BSA should have been valued at, they used banking figures. You can't disentangle the relationship of this entity from the bank. Now, the court is absolutely correct that it's not a bank, and I'm glad it understands that. But this transaction couldn't take place outside of the bank. You couldn't take this entity and have it be a viable business in circumstances where it didn't have a custodial relationship. So you have to take the industry understanding and the regulatory understanding into consideration. And we do think that that's somebody with, again, real on-the-ground sectoral experience, as well as transactional experience.
Well, I understand that, but I still don't think it's a banking expert. It's someone who's got experience in this particular field of investment advisory functions and so on and so forth.
If we call it financial services, is that adequate?
Well, what is currently provided is evidence of experts in the following fields, which include the valuation of the first claimant's business, quantification of any loss. Well, I think you need one person for that. You don't need two. Quite what field you call him in is another question.
All right. May I just ask that we not be limited to questions of quantum in relation to that person, whoever he is?
Oh yeah, it's valuation. We're looking at the value of the business, and if you say it can't be sold because it has nil value, or it can't be sold therefore it has nil value, so be it. If the other option would be for you to produce a report, so to speak, at your risk as to costs, to see if it's any different from what the other chap's going to say. You know, what's the difference really going to be is what I'm asking. They're going to put figures on something or not. I can't currently see that there are two distinct areas of expertise involved, but maybe that's me being dense.
Well, I think that for today's purposes, we can probably settle on the two as long as we have liberty to apply if it occurs to us that it's not
always liberty to apply. If you suddenly find there's a distinct point of expertise that the person you've first gone to can't cover, and you find someone else who you think can, then you can apply to the court and we'll see. And all well and good. If we have both those who are dealing with the quantum of loss and what I call accountancy expertise meeting together to decide what documents they need, the question then which follows is, do they then need to meet also to decide on the methodology of valuation, which is often a very helpful thing, so we don't have ships passing in the night. Now, I appreciate if you say that there's no workable methodology because you couldn't sell it at all, you may not want to embark on that, but you may have an alternative case, in which case methodology is important. So what I would suggest is that we make provision for the experts to meet to determine, one, what documents they need, and two, what methodology they propose to employ when they set about their valuations. That may mean more than one meeting between them.
Mine will be very happy with that. That makes sense. And actually, the two, I know your logic's getting at this exact point, but the two are highly interconnected because the materials that you need are dependent on the methodology that you choose.
Absolutely.
And you're right that it is not helpful for the court. I mean, we'll see what the experts say, but it's not helpful for the court if the methodology is totally different, unless there's a really good explanation for that. So my learned friend's primary case might well be that it should be given no value, but she may want to run a secondary case that if contrary to that, the value is X.
Yeah. So again, the only question then would be dates for agreeing the list of expert issues, dates for identification of the experts in question, and dates for them to meet with a view to sorting out those two matters before we ever get to filing of experts' reports. You should be able to agree those, shouldn't you? He says.
I would think so.
Hopefully, but
Hopefully.
Track record of agreement's not too good so far, but yeah. Right.
And then, my lord, I think there's no need for my learned friend's 36, which is this point about issues of Swiss sovereignty. I mean, I think there's going to be a liberty to apply.
We'll have a liberty to apply so that if there's a problem, you come back. Yeah.
Brilliant. So, my lord, that we're nearly there. We've got to. My lord, I'm just conscious. How are you doing for time? I mean, I'm hoping that we can have this all wrapped up before 2 p.m. UK time, if that's convenient for your lordship.
It's convenient for me. I'm thinking more in terms of the court in Dubai, which we're keeping them late and so on and so forth. Where are we now? Half one. So it's only 4:30. Yeah, it's not too terrible. Yeah. No. Let's finish it by 5 in the next half hour, provided both of you are happy with that.
I am, my lord. So the next point I'm going to deal with hopefully very swiftly These are just the costs of the CMC that we had before you on the 26th of January. And that I know it's a while ago, it's quite a lot of water has passed under the bridge. Your Lordship reserved the cost. That was a hearing which we asked for on receipt of the strikeout application and the counterclaim. And your Lordship will recall that neither of those two applications had been foreshadowed properly in correspondence. They came essentially out of the blue. And what the defendants were actually asking for in the counterclaim was that we plead to the claims against the liquidator, which included very substantial claims for personal liability and damages. And their counterclaim was premised on the basis that claim would come to trial at the same time as the trial of the main action. Whether your Lordship thought it was a good idea or not, we suggested that the liquidator removal application ought to come on first because it wasn't tenable for the liquidator to continue in office whilst allegations, such personal allegations, were being levied against him, and that plainly the issue ought to come on ahead of the trial of this action. So that is what the CMC was about. We were successful on all of the points that we ran at that CMC. But your Lordship reserved the cost, I think, because your Lordship wanted to see what happened on the removal application and also the strikeout application.
Yes.
And on well, we all know what happened on both of those. But on both of those applications, we were successful with our costs. And on the removal application, your Lordship ordered over 90% of our costs, which you assessed summarily. And on the strikeout application, you also ordered costs in our favour and gave us a very substantial payment on account. So we say that on any view, we were both, one looks at the content of that CMC, but also the outcome on both of the applications. We were the victors and we would ask for our costs. And I understand that it's a bit tedious to have to deal with costs, but I'm afraid to say we have been on the receiving end of this war of attrition from the defendants, and their entire strategy is to cause us to run up unnecessary costs in the hope that that will somehow discourage us from pursuing this litigation. So it does mean that where we are successful, we do need to come back and ask for those costs, because otherwise it just essentially vindicates their strategy. So anyway, my Lord, that's my submission on the principle. And we have a cost schedule, and I'll just get you the reference for that. But I mean, these costs are very modest in the grand scheme of all of this, because it was a short hearing. So 1669. 1669. And the figures are 1670.
Yeah.
So my Lord, I don't need to address you on the amounts. I mean, they are what they are. We had to move very quickly. These, as I said, weren't foreshadowed at all. And if one picks through, we don't need to do this now, but if one picks through the transcripts of what happened at the hearing, we were successful on everything that we wanted. And the hearing was necessary because none of this had been foreshadowed, and it had been presented in a very unsatisfactory way, where the liquidator was being told that he would be substantially personally liable, but that the issue wouldn't come on for some considerable time. So it does matter to the estate, and that's why I'm here asking you for our costs. And those are my submissions.
Mrs. Martin?
I'll keep it brief. I hesitate to remind the court that we did ultimately prevail on the removal application, and so it's not, I don't think, fair to say that the claimants prevailed in all regards. I do recall the court saying at the time of the CMC it considered this particular hearing to be inevitable in any regard, and we would suggest that for those reasons that the cost be in the case.
What did I do on the application for the removal of the liquidator?
So notwithstanding the fact that the liquidator was removed, the liquidator recovered his costs for the estate, and your lordship assessed them at over 90%. So we were actually very successful on costs on that, and obviously on the strikeout as well. So I mean, we would say the logic of that would mean that this should go in the same direction.
Did I not make any deduction at all? Yes. By which I don't mean deduction in terms of quantum, but deduction in terms of principle.
No deductions in terms of principle. I'm looking to I'm looking to.
But when assessing deduction, the judgment reference was made to the points on which the liquidator failed.
So my junior, I'm very grateful to my junior. He says that actually, as we understand it, it was a broad assessment by your lordship that took in, so your 90% just took into account all of the features, then the points that went well and not so well in all of that. So I think you would say the principle is wrapped up in the principle with an LE rather than AL, was wrapped up in the 90%.
All right. Well, on a similar basis, you get 170,000 dirhams.
I'm grateful, my lord. My lord, so that brings us to the final point, which is a different agenda item. But
could there was one issue on the order that I actually would like to address that I think got kind of skipped over.
Yeah.
That was just a point about trial testimony, and we have 2 points in that regard. And one of them is just sort of coming into formation after discussions leading up to the hearing. But the first one is just that we would ask the parties and the court to anticipate that following the Swiss process will be necessary for trial testimony. And our draft order provides for letters rogatory be provided to the court 14 days after claimant's responsive witness statements, which I recognize that the court may not be minded to order responsive witness statements, but in any event, we think that it should be staged shortly after all the parties feel that their fact witness evidence is complete. And I understand that Mr. Shibji believes it's our responsibility to take that process forward entirely, but if he intends to follow the process, he'll need to engage, because you have to put questions in requests for trial testimony. So that is just something we would ask all parties to, and the court, to be aware of, and that we intend to follow. We just further wanted to make the court aware that our clients remain under the threat of criminal action by the Al-Kharafis. And so, as the court may remember, criminal actions are, or may be aware anyway, that criminal actions are de rigueur in the UAE, and they are filed almost as a matter of course by a certain subset of the local bar, including against arbitrators. So while the practice is reprehensible, we can't discount our clients and potential witnesses' concern that they may be at the very least subject to a travel ban in the UAE, which would allow them to enter but not exit, effectively barring them and prohibiting them from seeing their families and workplaces for how many ever months, or it can last years. So of course, they might also be subject to arrest and imprisonment, because these are criminal allegations that are being lodged, and they understandably aren't willing to undertake that risk. And so we would just ask the court to be prepared to accommodate video testimony for that reason.
Yes. What are you actually asking me to order, though, today?
I didn't know if that was something I needed to raise now for the court's attention, just so it doesn't come as a surprise later. If it doesn't need to be ordered today, that's fine. I just wanted to make everyone aware.
Right. Well, I mean, it's not uncommon these days for witnesses to give evidence via video link. I think it's unfortunate in a case where credibility matters. But if there are reasons of the kind that you're putting forward, then that may be entirely understandable. So that's a bridge to cross when we get there, I think, rather than anything else. Yeah.
Thank you.
So, my lord, I think moving on to the final topic, which was my learned friend's application for permission to appeal your lordship's decision on in dismissing their strikeout application. Now, the question for actually whether you should grant permission is not for today. There is simply a question, and we have no one's put in submissions on that, so I'm not asking you to start considering the detail of any of that. But we say that there is actually just a short preliminary point, and it would be helpful to address it today, which is that the appeal was filed out of time. And if we're right that it was filed out of time, then they are in the territory of applying for an extension, and the authorities explain that this is a relief from sanction scenario. And as your lordship knows, the principles on relief from sanction are strict, and we say that they're not entitled to relief. So I just wanted to address you briefly on that, and I think it would be useful to deal with that point today, because if we're right, that is actually just the end of the matter, and that's one thing taken off the court's desk. And if we're wrong, then the case will need to go forward to deal with permission. And my learned friends have actually asked for an oral hearing on permission, and we would obviously have an opportunity to put in written submissions and appear if we wanted to. But we don't get to any of that if we're right that they're out of time and that they don't get an extension.
If I refuse an extension, can Mrs. Martin go to the Court of Appeal and ask for an extension? No.
No, she's not. She can't. No. If the appeal is out of time, such that they've just missed the window, then that is the end of the road for them.
She can't renew her application for an extension of time to the Court of Appeal.
My junior says, and it makes sense to me, that she could appeal the decision to reject the extension. So
yeah, that's what I thought.
Yeah, so that. Sorry, my lord, if
yes. I didn't think she'd be shut out forever on all fronts. I mean, there are some applications where you actually are, but they're very few and far between.
So my lord, perhaps I can just address you on this. I mean, we say that the law is strict, and it's obvious. I mean, we're not pursuing this point for sort of any advantage other than it is a way of trying to simplify this case so that the parties can actually spend time preparing for trial rather than over the next 6 months get distracted with an appeal. And I say that, I don't know if your lordship has had a chance to have a look at the draft appeal and what is being suggested. But actually, what they've asked you to do, what they've asked the appeal court to do, is to overturn your lordship on a narrow point about the interpretation of Article 9(1) of the Law of Obligations. And your lordship may remember that there's this point about whether or not under DIFC law, one has to show that fraud is a necessary ingredient of the course of action in order to take advantage of the unlimited time period. And your lordship may remember that when you looked at this, there was a decision of Mr. Justice Steele in the Carafi case, and he had looked at the interpretation of the legislation and compared it to the English one, and there are some differences between the DIFC and the English one. And Mr. Justice Steele's view was that there was, even though the language was different, substantively the legal principle was the same, and your lordship's view was that the language was different, which meant the regime was different. But anyway, that is what the appeal concerns, and what they're asking you to do the Court of Appeal to do is to decide that point and then remit the matter back to your lordship, essentially for a further hearing to decide the consequences. And we'll come to this if we ever have to argue the merits of permission. But what the entire application overlooks is that your lordship found against them on 2 points. You found against them on the interpretation of 9.1. But contrary to that, your lordship also found that on the causes of action pleaded in this case, fraud was a necessary ingredient. And your lordship relied on the Paragon Finance decision and that decision in Cunningham and Ellis, both of which make clear that a fraudulent breach of duty or a fraudulent conspiracy, unlawful means conspiracy, are a different cause of action. And their appeal they don't actually appeal that your lordship on that point, and there's a sort of slight side attack on it in their skeleton, but nothing in the grounds of appeal. And so, I mean, this appeal, we're not very enthusiastic on getting into it because it looks like the sort of exercise that will cost a lot of money and actually not illuminate these proceedings at all. And even if one was enthusiastic about this point about Article 9.1, it takes you nowhere because of your lordship's findings on the causes of action. But anyway, these are all. This is just my run up, my lord, to the extension point, and I hope I will never have to come before your lordship to argue on permission to appeal. But I just wanted your lordship to be aware that certainly on our analysis, it's a entirely academic appeal that actually will have no bearing on the outcome, no bearing on the trial that your lordship will conduct, and that's why we are trying to shortcut matters by putting it to bed now. My lord, just to explain to you how the DIFC regime works on the timing for an appellant's notice. The essence of it is that the time for appealing runs from the date of the decision, and that actually reflects both English law under CPR 44.10 and also the RDC. And sorry, if you just give me a moment, I'll get my reference.
It's 44.10 of the RDC.
I'm
Correct.
so sorry, it is 4410. You're right, it's 4410 of the RDC, reflecting the English part 52. So my lord, does lordship have that to hand?
Yeah.
So it says 44.10 sub 2, where the lower court makes no direction within 21 days after the date of the decision. And the decision my learned friends are seeking to appeal is your lordship's decision dismissing the strikeout application. And you can actually see that from their appeal notice. If we go to their appeal notice at 689. It's not in the most, unfortunately, digestible form. But at the end of the appeal notice at 690, they set out the orders sought, if your lordship can see that, just in the middle of that main paragraph at 690. And the orders sought as number 1, the appeal be allowed. Number 2, orders 1 to 3 of the orders made by the primary judge on the 30th of April be set aside. Now, orders 1 to 3 were the orders dismissing the strikeout application and ordering costs. Now, they've quite cunningly referred to your lordship's order of the 30th of April, but actually that was an order your lordship made on the 19th. The dismissal of the strikeout application, your order made on the 19th of April. Now, my learned friend's argument is that the court only gave an indication on the 19th of April that it would dismiss the strikeout application. And they say that an indication is different to a decision. And because it was only an indication, your lordship didn't actually make the decision to strike out until the 30th of April. And we say that is just a rewriting of history, because it's obvious from the transcript that your lordship made a decision to strike out the application. And it's also clear from what happened afterwards, including what my learned friends actually did, and I'll show you that too. So if we just look at the transcript of what your lordship said at that hearing on the 19th, that's at page 1417. And just to relive for a moment the structure of that hearing, what happened was on the first day, my learned friend took 3 preliminary points, which she said were really the knockout blow. And she ran those first and really sought to persuade your lordship that she could get home on those. And essentially she didn't. And so your lordship then went into the full hearing where you heard the full, I think, 83 points over the course of 2 days. And at the end, this is what your lordship said. You say, all right, well, I will give you my reasons in writing subsequently, but I'm clear in my own mind that the defendant's applications both fail. And in my judgment, they were misconceived in the first place. And then you go on to give some explanation as to why that was your view. And then in that hearing, we went on to ask for our costs because we had been successful. And when you turn to 1466, your lordship goes on to say in the first paragraph what you had already done that hearing. I refused her applications on summary judgment and strikeout, so she will have to pay the costs of that. And then you went on to make a cost order and to make a payment on account order. Then at the end of the hearing, my lord, you asked the parties at 1470 to draw up the order. And for me to draw up the order and then to agree it with Miss Martin's team. And again, that's only consistent with your lordship actually having made a decision. Now, while Mr. Devonish has filed a witness statement saying that his understanding is that you only gave an indication, it's striking that his position after the hearing was actually that you had made an order. And we put forward a draft order for their approval. They had some changes and they sent forward their own draft order. But their version of the draft order also provided, like ours, that the applications had been dismissed. So it seems that both parties understood following the 19th of April that that's what your lordship had done, not that your lordship was still reflecting on the position subject to making a decision later. And your lordship will also remember that this was all running concurrently with the appointment of the new liquidator. And at that point, the defendants were pushing your lordship to issue the order because they wanted to include in the order a mechanism at this CMC for appointing a new liquidator. So actually they were pressing your lordship on to issue the order, and with the agreed part that we had dismissing the applications, because they wanted some collateral language that said that in the absence of an agreement for the appointment of a liquidator, that issue would be dealt with at the hearing today. So the shoe is slightly from the other foot, but at that stage they thought an order had been made. And that's also reflected in fact, the agreed case memorandum that they've agreed as well for this hearing, and that's at 484 of the bundle. And you'll see that at the bottom, my lord, it lists what happened 18th and 19th of April, and it said the court heard and dismissed the defendant's strikeout application, and that's an agreed case memorandum. So time started. The date of the decision, which is the key point for the DIFC rule, was the 19th of April. That's when time starts running. We don't actually know when their appeal notice was actually, where the fee was paid for it to be issued, because they haven't. We've asked them repeatedly in correspondence, but they've just ignored that request. We think it was likely that it was issued on the 22nd of May, but even if it was issued a day or two earlier, it was still well out of time, because if time started running on the 30th of April, then it ought to have been issued, I think, by the 10th of May. Now, admittedly, it isn't the largest delay of all time, but your lordship knows why we're here. We're here to try and shortcut matters, and we say the rules on the extension of time are strict. Now, where an appeal notice is out of time, a party must apply for an extension in their appellant's notice. They haven't actually done that, but they do try to sort of hedge their bets in the supporting evidence for the appellant's notice. And the rules provide, this is 44.13, that where you're applying for an extension of time, it needs to be in the appellant notice, and you also need to have within it a statement of the reasons for the delay and the steps taken prior to the application being made. Just turning to the substantive point about whether an extension should be granted, the authorities make it clear that that is dealt with under the law of relief from sanction by reference to the Mitchell principles, and we rely on the Hysaj case, which is in your bundle at 9917. And that was a decision of Lord Justice Moore-Bick. And there was an argument which has developed at significant length about whether or not one should really look at an extension of time for an appeal notice as relief from sanction, where actually on the face of the rules there isn't an immediate sanction that flows from filing your appellant's notice late. And if your lordship could read paragraph 36 of his judgment, I'd be grateful.
I got the wrong page number.
1917.
1917, thank you.
So it's applied as a relief from sanction. I mean, it's to some extent it's sui generis because it doesn't necessarily look like other relief from sanction cases, but the law is well established, and that's the approach that the courts take. And so there are three questions then for the court in deciding whether to grant an extension in these circumstances. The first is, was the breach serious and significant? The second is, do the defendants have a good reason? And the third is the relief just justified in all the circumstances? So the first question is the breach serious and significant? It's admittedly about just over 10 or 12 days. But if we look at the Smith and Bow case, which is in your bundle at 1888, this is a decision of Lord Justice Brooke. And he explains that the time limits is at the end of 54. He explains that the time limits for appeals has to be respected. And the reason for that, of course, is that essentially it's the importance of the finality of litigation. And he says that that rule of the finality of litigation is a rule of what he calls high public importance, and that extensions is at the end of 54. The extensions of time are reserved for rare and limited cases where the facts justifying the exception can strictly be proved. And so we say that this is it's tough luck. You're out of time. There are very short time limits for bringing appeals, but they're there for good reason. That then brings us on to the next question. Do the defendants have a good reason for missing the deadline? Now, there's no suggestion in Jones Day's evidence that they didn't appreciate the possibility that the date of decision was the 19th of April. Indeed, it seems likely that they did appreciate that was the position, even though Mr. Devon has subsequently thought that the court had only given an indication. There's no suggestion that they misunderstood the position in time, and the only explanation that they offer for why the appeal notice was filed late is that they didn't get the written reasons until the 30th of April. But that's a non-point because they knew the logic of your lordship's position, because it was argued in a great deal of detail at the hearing. And your lordship asked some questions about Article 9.1. You had a debate with me about that. That's at 1.220 of the transcript. And then Miss Martin came back in reply and re-argued that. And that's at 1.247. So the Article 9.1 point was a short point, and your lordship's judgment simply reflected the submissions that the parties had made on it. And it was in any event open to them to file an appellant's notice without their skeleton, and they were aware of that possibility, and Mr. Devenish also refers to that in his evidence at 717. And they also say that they were waiting for the transcript, but that's a non-point because they had 6 fee earners from Jones Day attending the hearing, all of whom were on their cost schedule at full rates. And between them, they must have had a very good note of the hearing. So it can't be said that they needed to see the transcript on Article 9.1 to understand what the point was. So the truth is that none of their reasons for the delay bear scrutiny. And of course, what was going on concurrent with this was their attempt to appoint their own office holder. And that happened. There was obviously that creditors meeting on the 29th of April. And then their subsequent application that Miss Easton hadn't been validly appointed. And so it may well be that they made a tactical decision that if all of that came to success, then this appeal wouldn't be necessary. But we just don't know because they haven't given your lordship the full and frank disclosure that they would need to if they wanted relief from sanction. And so putting that together, is relief justified in all the circumstances? Well, we say the rules require them to explain the steps taken prior to the application being made. They don't do that. The rules require that to be set out in the appellant's notice. They haven't done that. They don't mention in their evidence when they decided to appeal, when they started preparing their appeal. They don't say when they first appreciated that there might be a risk that they were out of time. They plainly envisaged, or they plainly realised that they were potentially out of time because Mr. Devenish deals with this possibility of an extension of time in his evidence. But they waited until they'd completed all of their appeal documents and their skeleton argument before raising the point with the court. And we say on the classic application of the relief from sanction principles, they should not get an extension. So, my lord, for those reasons, we say your lordship should find that the decision was handed down on the 19th of April. That's point 1. That accordingly, the appellant's notice was issued out of time. That's point 2. And then point 3, that the retrospective application for an extension of time should be refused on the basis that it doesn't meet the relief from sanction principles. And those are my submissions.
Yes. Mrs. Martin.
It would be a mistake to rely on the claimant's submissions as they relate solely to the CPR regime, and this is one of those circumstances in which the DIFC regime is different in 2 important regards. First, the DIFC is explicitly reliant on context for a determination of when a decision is made. There's no such corollary rule in the CPR as I understand. So RDC Rule 44.2, subsection 3, excuse me, the citation didn't make it into my hearing bundle. Hold on.
I think it's 2527.
Correct. Thank you very much. So 44.2 subsection 3 says, unless the use or context otherwise requires decision means an order or direction, or where a matter is to be disposed of otherwise than by an order or direction, the pronouncement of the disposal. So the High-Sag case that Mr. Shivji cited doesn't address this particular feature of the RDC because the CPR just doesn't have that feature. So let's look at the context here, and I want to go back to what it is that the court pronounced on the 19th of April. If we look at page 1417. Court did begin. I am clear in my own mind that the defendant's applications both fail, and in my judgment, they were misconceived in the first place. There are plainly issues of fact that have to be dealt with. Just want to underscore that. Issues of fact. The pleading, to my mind, is sufficiently clear in the essence of what is said, and the defendants have no difficulty and have had no difficulty in pleading to it. It is quite plain that this case is about, or what this case is about, and whilst there may be doubt about particular courses of action, the overall scheme of what is done and the conspiracy involved appears plainly from the pleadings and from the evidence that has been adduced. I can see no basis upon which there is any plain, obvious point of law, which ought to be decided now, which would justify a strikeout, and the factual issues are such that there can be no question of dealing with this claim on a summary basis. I will set out my reasons in writing, so they will all be there for you, which you should get as soon as essentially I can draft them and the court can process them. It is likely to be early next week. Now, what this statement indicated to the defendants is that the court had considered all arguments to be simply too factually driven to be determined now, meaning they were essentially preserved for argument at trial. So the pronouncement at the hearing, such as it was, did not forsage that some decisions were, in fact, as Mr. Sheepjee put it, narrow legal determinations that had the potential to be dispositive of certain claims now. Nor did it indicate that the court would explicitly split the DIFC authority on when fraud is considered to be an essential element of a fraud claim. Thus, even under the standards set forth in the Smith case cited by the claimants, even if those are observed, we would turn the court's attention to paragraph 41 of that case, which is found at page 1886 of the bundle. Which factors in that all the material necessary to produce a notice of appeal on the grounds which I have identified was clearly available to the appellants immediately after the judgment was given. We say that that just simply isn't the case here because our reading and our understanding of the court's comments at the hearing were that the applications were being rejected as being too factually based. So the same cannot be said here until the defendants received the order on the 30th of April. And we would further note that in the Smith case, at page 1885, also in paragraph, apologies, I'll pick the paragraph up, but that the description of a delay of 1 or 2 months was described as short by this court. Sorry, paragraph 36. So we would suggest that even though Smith relates to a different set of rules, it is supportive of our arguments here. Now, we of course recognize that the sealing of an order is not the determinative step. There is case law here in the DIFC on that, and that if not most circumstances, the pronouncement of an order with reasons at hearing does constitute a decision. The court may recall that this is how we counted the days in relation to our jurisdictional appeals, where the court might recall that it read its reasons into the record, allowing us an opportunity to prepare an appeal on that basis. So here, in this context, which must be taken account of according to the rules, we would only have had 10 days from the time we received the court's reasoning and 4 days from when we received the transcript to prepare our application. We would suggest that it would affect a miscarriage of justice if this court were to make law in this jurisdiction saying that in circumstances where the party against whom an issue was ruled don't have all the information to formulate an appeal, that they should still be required to file it, particularly in circumstances where the additional time that begins to run in the clock, like still might not make adequate time. It's expensive to file an appeal, and so to force a litigant to file an appeal before they've had a chance to fully consider the circumstances, again, is contrary to justice. So for these reasons, we contend that the decision, as that term is used in the rules, was communicated on the 30th of April, and that the appeal was timely filed. The court's own system shows that the filing date is the 21st of May, and the claimant's deemed filing date therefore has no merit. If the court is minded otherwise, and the claimants do remain wrong that an application for relief from sanctions was required, and further wrong that the Denton test applies, this is because of the second way in which the RDC and the CPR differ. RDC 44.13, or apologies, I did just want to draw the court's attention to the case, how it appears on the docket here, which is found at page 2526. And so the registry has deemed the appeal to be filed on the 21st. And as a basis of comparison, we show a circumstance where a document appears to have been submitted in the system on the 13th. This is a first witness statement by Mr. Hayter, and the filing date was deemed to be the 14th. So that is how it would appear in the system if the registry considered that this were filed after 4 p.m. But that's not the case here. So if the court is minded otherwise, and then the claimants do remain wrong that an application for relief from sanctions was required, and getting to the second significant difference between the rules. So RDC 44.13 states that where an application for an extension of time is required, you simply put it in your appeal notice, and this provision self-evidently relates to out-of-time filings. It makes no mention of relief from sanctions, and this omission needs to be taken as an intentional choice by the drafters. The DIFC court's out-of-time filings cast the court's powers regarding appeals as special powers within Part 44, not general powers within Part 4. This stands in contrast to the CPR, where the general case management powers for extension of time directly applies to appeals. And if the court is interested in taking a look at the rule, it can be found at the case bundle at 2383 through 85. That is Rule 52.6. And it specifically makes reference to Rule 3.12 A and B of the CPR. No such cross-reference is made here, and in fact, the cases in the DIFC differentiate the basis of the power. Sorry. So we would draw the court's attention to the Zuzana case in that regard. And that can be found at page 2457 in the bundle. And if we go back to paragraph 37, it makes clear that the issue before the court was a suggestion by the respondents there that the court has the requisite powers to make extension of time pursuant to rules 4.1 and 4.2. So if you read through paragraphs 41, it stands for the proposition that where a party seeks permission to extend the time for service of an appellant's or respondent's notice, the relevant provision contained in RDC 44, that being 4413, for the appellant, or 4481 for the respondent, is the special provision. And so the general powers to extend time under RDC 4.2 do not apply. Therefore, a party must comply with the special provision, being that an application for extension of time being included in the appellant's notice. In this case, the respondent failed to, in the Zuzana case, the respondent failed to submit its respondent's notice and instead applied directly to the court for an extension of time. This was deemed not appropriate, as any extension needs to be sought in the context of an appeal. The court did not refer to the Denton test. Now, the High Sage case cited by Mr. Shibji, the court appears to be reading. Please let me know when you're ready to move on.
Yes.
All right, so the High Sage case cited by Mr. Shibji, if we go back to page 1913.
Yeah.
If we go down to paragraph G, it confirms what the rules already say, which is that an application for extension of time invokes the CPR's general rule on case management powers. So contrasting that with the RDC, the irrelevance of Part 4 powers in this regard, we would contend negates the need for a separate application for relief from sanctions. But even if the court were inclined to review an extension under a test analogous to Denton, it can still do so without requiring a separate application, and there is precedent for that. There, we would turn to the hearing bundle at 2461 through 62, paragraphs 12 through 15. Just by way of background, this was the defendant filed its appeal notice 13 days late and sought an extension, and it was granted on the basis that it was not serious or significant. And whilst the reasons for the delay were not compelling, that being the banking system at ADCB not working, it was explained. And the delay caused no significant prejudice to the claimant or to the court. And whilst this was a small claims tribunal case, and so the rules are slightly different, that being the bespoke rules 53.110 and 53.111, they're not identical to Part 44, but they are analogous. So the claimants are further wrong that the better course would have been to follow the path set forth in RDC 44.30, which would have allowed us to file an appellant's notice without filing the supporting materials. But they claim an interest in the speedy and efficient resolution of proceedings. But if we had followed that course, then the defendant's steps got the pleading to the court 10 days faster than that procedure would have. So the defendants maximized procedural economy, imposing no prejudice on the claimants or the overall system. Substantively, although again, we don't want to get into the merits here, we don't think it's the appropriate place, but I would ask the court to keep in mind that this is a classic case for appeal. There now exists a split in authority on what constitutes the core elements of a fraud claim and how that impacts statutes of limitations defenses for defendants accused of fraud. It is a legal issue. It is an issue of great importance to the entire DIFC legal community. The claimants know this is a meritorious appeal, and on our view, we have now defaulted the opportunity of submitting evidence contesting the merits of granting permission, or rather that they have, unless the court orders otherwise, we submit that their evidence, their opportunity to provide evidence was on Wednesday, and that the evidence they chose to supply didn't relate to the merits of the appeal. It only related to this procedural aspect, and they should be deemed to have defaulted on their opportunity to submit such evidence. Lastly, I would say, just as for why we included those, the additional language at the end of the witness statement, it's not because we believed that the application was out of time or that we believed there was an even real risk that it was out of time. It's because we just take note that anything we do in this case is always deemed by the claimants to either be early or late, or sometimes both. But in this case, we knew that this is one of their sort of go-to bag of tricks arguments, is question the timing of something as either being late or premature. And so we just anticipated that they would make this argument and included the additional information for that reason. Those are our submissions on the timeliness of the appeal.
Yes, Mr. Shivji.
So, my lord, this is an entirely academic appeal, because as I've explained to you, my learned friend didn't even deal with it, that because of your decision on the back of Paragon Finance, which is a decision of long standing in Cunningham, the ingredients of the causes of action of fraud anyway. So this is, the court should not be wasting time, we say, with this appeal, which is why we wanted to bring it to a close early. The decision that is being appealed, and I showed you the appellant's notice, is your decision to dismiss the strikeout application. And it is clear that the date of that decision was the 19th of April. That is absolutely clear from the transcript. My learned friend sought to give the impression that the reasons that your lordship articulated at the hearing were focused solely on the facts, and that it was a surprise, therefore, to hear what your lordship said later in the written judgment. And that isn't a fair characterisation of the hearing. So I explained to you earlier that the hearing essentially operated in a two-stage way. There were these preliminary points, my learned friend's best points, which she ran first, and you didn't find favour with those, which is why we ended up doing them with the other 80. But her best 3 points included this point, and so she argued the Article 9(1) point up front as part of her submissions on fraud. And if we just pick up the transcript at 1207, this is my learned friend in reply on those issues. Sorry, 1 second, my lord. My imagination's got a bit funny. 1 second. Sorry, my lord. It's 1247. And in the lower half of the page, she's just dealing in reply with the statutory language article 9(1), and she's making some submissions there about the difference language, and that's because your lordship had a debate with me about that, and then had a debate with her about that. And then so your lordship heard the end of her 3 arguments, and then if we go forward to 1251, you say, and this is during the course of day 1, you say in the middle of the page, well, subject to further reflection, because I may of course have further and better thought, I can't see any basis for striking anything on the footing of your submissions. And then you make a point about Article 80, which was the summary remedy for misfeasance. And you say, concerned about that. And then you say at the bottom of the page, in every other respect, and this must include the Article 9(1) she's just been addressing you on, it seems to me that there is plainly room for argument about the principle of law which are applicable, and it would not be appropriate to reach a decision in the context of a strikeout or summary judgment application. So I'm against you, Miss Marston, in relation to your application on every particular, so far as except potentially the Article 80 point. So my note is quite clear to them that they had lost on the Article 9(1) point that she had addressed you on. And then the bit I showed you was the following day, where your lordship had the chance for further and better reflection, and that's when you then dismissed the whole application. So we say, my lord, on any view, the date of the decision for dismissing the application was the 19th. And the logic of my learned friend's point is that if you sort of actually dissect the decision and connect it to the reasoning, then the date of the decision will vary according to the particular reason identified. So you might say, well, the date of the decision for dismissing the application on a factual basis was the 19th of April, but the date of the decision on a legal basis was the 30th of April. And it only requires analysis in that way to realise how absurd their position is. So we say it's obvious that it was the 19th of April, and they plainly realised the risk, which is why Mr. Devonish identified it in his evidence. And then moving on to the second point, my learned friend's argument really is that the DIFC regime for extensions is different. That isn't right. And actually, one of the authorities that she took you to a moment ago, which was the Mako and Marley case, the court applied exactly the same analysis, the relief from sanction analysis. And this is her authority. And you can see the relief from sanction analysis being applied at 2461 at paragraph 13 onwards. And this is a decision of Justice René Lemaire. And then she goes through relief from sanctions. She first of all deals with whether delay is serious or significant, then their explanation for the delay, and then the question of prejudice. So we say that it's well accepted in this court that the usual relief from sanction rules apply in relation to extensions of time. And my lord, I make no bones about the fact that this is a way of the claimants cutting short what we say is an unmeritorious appeal. And my learned friend says that filing an appeal notice is expensive, but dealing with an entirely academic appeal is even more expensive. And the court can be saved of the delay and the cost and all of that if you accede to our view. So, my lord, those are my submissions.
Yes, thank you.
Going back to the quote that Mr. Shivji took you to, we would submit that that supports our position. What the court said is it would not be appropriate to reach a decision in the context of a strikeout or a summary judgment application. It didn't say that it was deciding against us. It said that it was deciding not to decide, which is entirely different from disposing of the issue with finality, which we viewed the decision to do on April 30th. But we didn't have the opportunity to have that information until we read it in the statement of reasons. This is exactly what the rules forsage and allow in requesting that a decision, the definition of decision, take into account the relevant context. This context is relevant, and it drove our decision-making and the timing of our decision-making. In terms of the case that Mr. Shivi referred you back to that we cited, the point there is that the court didn't require a separate application for relief from sanctions. It did analyze the issue under the principles, but to the point there suggesting that a separate application is required here, there's just no basis in the rules to suggest that. We, again, would submit that under those rules, if the court deems that there was a delay, that the delay was not serious and significant by reference to the other cases that we've found on the topic, that we submit that there is good reason for the delay, which is that we didn't realize that there was a final legal appealable issue until we read it on April 30th. And that is explained for that reason, and that the delay causes no prejudice. In fact, there is a benefit to the claimants because they got all of our documents at once rather than 42 days later, as might be contemplated under Rule 4430.
Thank you very much. The defendants apply for permission to appeal against the dismissal by me of their applications for summary judgment and strikeout of the claims made by the claimant. The claimants, however, say that the application for permission is made out of time, not in accordance with the rules. The claimants also say that an extension of time is not appropriate, whether on the basis that this seeks relief from sanctions or otherwise. The terms of the relevant rules are to be found in RDC 4410 subparagraph 2. The appellant must file the appellant's notice as referred to in Rule 44.6 paragraph 2 within 21 days after the date of the decision. A reference is then made to RDC 44.2 subparagraph 3, where it is said that unless the use or context otherwise requires decision means an order or direction, or where the matter is to be disposed of otherwise than by order or direction, the pronouncement of the disposal. From any reading of the transcript of the hearing, it is plain that I made a decision in favour of the claimants, refusing to strike out the claim and refusing summary judgment in favour of the defendants. I did so both on the points of law which were advanced, which I considered were not capable of decision on a strikeout or summary judgment, and also on the issues of fact which again were inappropriate for summary judgment or strikeout. There is no doubt in my mind whatsoever that I made a clear decision on that day, refusing the applications made by the defendants, and they could have been in no doubt about that whatsoever. As it turned out, because there was a dispute about various parts of the formal order, and because issues arose in relation to the removal of the liquidator and the appointment of a fresh liquidator, the court did not formally issue an order until some 11 days later, on the 30th of April. However, it is clear in my mind that the 21 days allowed for an application for permission to appeal had expired long before the 21st of May, when the application was issued by the registry. The application which was made also failed to accord with the rules because of the terms of RDC 4413, which provides that where the time for appeal has expired, the appellant must file the appellant's notice and include therein an application for an extension of time, a statement of the reasons for the delay and the steps taken prior to the application being made. Because the application was made out of time, there was a need to comply with that provision, and the appellant's notice did not do so. No good reasons for delay were given, and the suggestion that the defendants failed to realise that there was a problem about the timing does not seem to fit with the correspondence which was exchanged at the time and various other documents, including now the agreed memorandum, case memorandum. So far as granting an extension of time is concerned, it does not much matter, it seems to me, for these purposes, whether or not we are truly in a relief from sanctions position or otherwise, although I take the view that what is required here is indeed relief from sanctions. The comparable position in the UK is absolutely clear, with plenty of authority to the effect that seeking an extension of time in these circumstances does amount to a relief from sanctions. Whether or not it is considered merely as a special application under the terms of RDC 44 does not make any difference to the decision I have to take today. The defendants the defendants knew on the 19th of April that their applications had been dismissed. They knew also the essential basis upon which they had been dismissed. And an application for permission to appeal is made against a decision and not against the individual components of a decision as such. The decision went against them, and they had time to apply in accordance with the rule, and no good reason for not making the application. They could have, should they so wished, put in an application for permission in time without skeletons or grounds of appeal and sought an extension of time to do so. They did not do that. In reality, the grounds which are now advanced are not grounds which in any event would avail them in the context of the decision which I took. The two grounds which are now apparently relied on could not, which are said to be points of law, are effectively academic in the context of the decision which I took for the reasons that I have already set out. There can be no doubt that the authorities established that the case as put had the necessary ingredients of fraud within it. And the point made as to Article 9.1 and its construction would not have been determinative in the light of the other reasons which I gave at the time. In these circumstances, whether or not this is technically a relief from sanctions, there is no basis upon which any extension of time should be given for the application for permission to appeal to be made. I should say that without having examined any of the details of the application for permission to appeal, it would, for the reasons already given, appear to me to have no realistic prospect of success in any event. But that is beside the point in the context of my ruling that the application was made out of time and no extension of time should be given because justice does not require it. The time set for appeals is deliberately set, having been raised at one stage from 14 days to 21 days, but is deliberately set in order that there should be finality, and these time limits must be observed unless there is very good reason and the interests of justice require that it should be extended. So for those reasons, I make the ruling that I do in deciding the application is out of time and that no extension should be given. Yes, thank you.
Milo, thank you for that. Milo, so I'm so sorry. Can I just raise one point from just earlier on when we were listing the September CMC? I've just heard from my, sorry, they sent me a message earlier, but my instructing solicitors said that the key members of their team have a professional difficulty that week. And I'm sorry to ask, but is there any chance of your lordship looking at another date? I think they're just concerned about team power on their side, and they obviously want to, they want to be around because it may well be that things move quickly ahead of the CMC, and we will need Fiona availability.
We were looking at the 16th, weren't we?
We were, yes.
Well, the only other possibility would be the 23rd. Those are the only two dates I've got in September.
It's absolutely fine. Yeah, so I think that's fine or not. Someone will shout at me if I'm wrong about that, but I think that works on our side. So thank you, my lord. 23rd would be much better. Yeah. Yes, I've had instructions. They're happy with that. Thank you.
Is that all right with you, Mrs. Martin?
I believe so. If we could just go back to the appeal very quickly, though, I just wanted to lodge my application for permission to appeal today's decision.
I'm so sorry.
I just wanted to seek permission to appeal today's decision.
No, refused. For the obvious reasons that I've already given. Right. Anything else today?
Not on my agenda. My lord, thank you so much for sitting late, and also thanks to the court staff as well. I know it makes a long day for them, but thank you for fitting us in. We're very grateful.
All right. Now, are you quite clear about the order you're going to draw up for agreement?
I am. I will. I'm conscious that there have been challenges in the past, but can I suggest that
it's actually I found extremely irritating.
Yeah.
The fact that having made a decision and left it to the parties to agree the form of order, I don't think one single order has as yet been agreed. And I've had to come back to it a few days later to approve a form of words and sort out a dispute between the parties as to what actually had been decided. If necessary, we will go through it now one by one to make sure there's no room for disagreement, but depends how confident you are.
Well, I'm afraid to say it might be worth doing that. I mean, I'm alive to the Lordship's concerns, but it probably is just worth running if we run through the draft at 1779.
Well, let's do that.
Just to make sure that we're all on the same page.
Let's do that. Right, take me through it then, Mr. Shivji.
So the wording in paragraph 2, the wording in red has been dropped. So it's just the wording in black.
Hold on, let me just get the page up. Yeah.
So it's the wording in red in 2 goes. I think the wording in red in 3 goes as well. And then on 4,
I'm not confident we actually agreed that on 3. On amendments to statement of case, we do suggest that to the extent the ruling on the strikeout application preserved some of our arguments for trial, that those amendments need to be incorporated into the statement of case.
Well, I thought I understood your Lordship's direction that they need to put forward a draft if they want to amend, and we'll look at that and we'll be sensible about it in the hope that we don't have to trouble your Lordship. So I can't see that having a blanket permission to amend without a draft is really going to work.
I don't want to give a blanket permission, but the ordinary rules apply that if there is a party wishes to amend, then I expect the other party to agree to the amendment unless there's a very good reason why they shouldn't. So I mean, I think that we don't need paragraph 3 as such, do we?
I think only that we wanted a permission because Miss Eason has been appointed as liquidator, and I think on our. I'm so sorry, my lord. I'm not sure you're absolutely right. I don't think we need to.
We don't need paragraph 3 at all at this stage. It's just the usual position that a party can apply to amend its case with a draft amendment, which it sends to the other side and seeks their consent, which should in the ordinary way be granted.
Yes, my lord. I'm grateful. So I'll delete paragraph 3. Then on what is currently paragraph 4, I'll just read that out to you because we've inserted some words. That says the defendant shall, pursuant to RDC 2814, file and serve evidence. So that picks up the existing wording, including from a senior officer of the 4th and 5th defendants other than the 1st to 3rd defendants, and a person or persons within the 4th and 5th defendants with direct knowledge of the matters addressed.
Yep.
And that's, as I understand it, to be done by the 14th of this month, so 4 p.m. on the 14th of June. And then on A, your Lordship suggested amendment on that. So A now reads, the individuals who are responsible for giving instructions to the defendant's legal representatives in relation to their disclosure exercise.
Yeah.
And then in 4D, just at the end, we've inserted including by way of exhibiting the defendant's relevant document retention policies and document preservation notices. And then the rest of So then the rest of it stays. But I said to you that I would drop J and K for the purposes of this hearing and pursue that in correspondence. They've been deleted. Then on paragraphs 5 and 6, it's the wording.
Well, hold on.
Sorry, I'm so
paragraph
sorry.
4, we've got different date ranges.
Oh, I'm so sorry, my lord. I'm sorry. Thank you for picking me up. That I'm terribly sorry.
G1 to 4 is June 2012 to May 2016. 5 to 7 is 2012 2018, and 9 and 10, as it effectively is 2015 to 2018.
Yes, and perhaps on 11, we would just have, if any, at the end, because it's a matter for my learned friends to decide whether actually on reflection there is a committee that fairly is captured by those terms, even if it's called something different. Thank you, my lord. So, my lord, then I think we were on to 5 and 6. Now, actually, in light of your lordship's,
I'm sorry, could I have some input on 9 and 10, that they need to be limited to those related to investigative work, not standard compliance functions.
So I think the language we had was relating to relating to
activities.
Investigations relating to investigations into matters related to the first claimant and or correspondence with regulators. Actually, so I've got the wording I've got is actually we should insert the 5th defendant as well. So it should be for the period 2015 to 2018 relating to investigations into matters related to the first claimant and or the 5th defendant and or correspondence with regulators in relation to such matters.
Yeah.
Thanks you to my learned friend for picking that up. So I think that's the remainder of 4. And then on
well, again, I think on the date ranges for the allocation of competencies, I mean, they have it for the relevant period.
I think we did argue this point, and actually I think we kept them as they are, because I think what you said was that they did them every couple of years. So I think that's why we kept those ranges.
I don't recall coming to a conclusion on date ranges for that. And
no, that's what we. Which item is it? But I recall that we had the discussion, and you said it was every 2 years that they produce these organograms.
I think that was H, my lord. I think
H.
Yes.
I don't think we're talking about. Well.
Yes. Allocation of competences. Yeah. Yes.
I mean, if the question is,
I think that's fine. 2011, 2018.
Well, nothing else is 2011, so I'm just wondering if we can, at the very least, bump that up to 2012.
Yes, that's fine. 2012.
Right. Yeah.
So I think that's the end of 4. I think for 5 and 6, in light of your lordship's direction for a meeting, I think 5 and 6 can just be deleted.
All right. Yes.
And then I think also the 7.
That's the letters rogatory point, which again right. We're dealing with separately.
Yeah.
So that comes out. 8, we've got an exchange now. Within a week, haven't we?
Yes, that's fine. So that would be the 17th of June.
Yeah, 17th.
Yeah.
Yeah.
So I think it should be the parties shall exchange
lists.
Yeah, I think yes.
And then seek to agree a list of BSA's clients by, say, the 24th.
Well, I'm not sure that. I think where we ended up, my lord, on that was that isn't necessary, because I think the purpose was simply for everyone to. I think what your lordship ordered were the list of clients for 2014.
Yeah.
And that we should each put forward, and then everyone knew where we each sat, and in any event, we'd have to revisit it after disclosure.
Fine.
So and I think it probably is helpful to keep the word preliminary in there, because certainly for our part, we committed as being our final effort. So we'll just say that the party shall exchange preliminary lists of BSA's clients for 2014 by the 17th of June.
Yeah.
Great, thank you. And then this is that the parties shall. This is moving on to paragraph 9, which is then I think where we insert your lordship's meeting.
Yeah.
I think we need to clarify that for the exchange of client lists, we can only do that from the 5th defendant, in so much as they have information or a belief about that someone was a BSA client. And as I recall, we were supposed to be putting forward a list of all of the 5th defendant's clients, which...
Yes, quite right.
Yeah. So the claimants will provide a preliminary list of BSA's clients, and the 5th defendant will provide for 2014, and the 5th defendant will provide a list of its clients for 2014, and that will be exchanged on Monday.
Yeah.
I assume for this purpose, client account numbers is sufficient.
Sorry, say that again.
I mean, generally, a lot of these accounts are done by numbered accounts, so.
But I think a list of the 5th defendant's client account numbers would be meaningless.
Numbers are not going to help at all.
No.
We need names.
Yes.
That's the whole point of the exercise.
Yes, agreed. So, my lord, then to move on to 9, I thought 9 is probably where we could find a home for the proposed meeting.
Yeah.
So there shall be a meeting of all parties, solicitors or legal representatives. Be a meeting of all parties, legal representatives, for the purposes of discussing and seeking to agree categories of documents and the extent to which these can form part of letters rogatory, as well as custodian search terms and date ranges.
Yep.
And that meeting to take place on either the 24th or the 25th of June.
Yes. Then draft letters rogatory by 12th July. Defendants to provide.
Yes. And I think 10 was already agreed, so the fourth defendant was going to provide an update about not any non-Swiss resident custodians, and if there are any issues there, and they can do that. Paragraph 11, I think goes.
Yeah.
And then actually, my learned friend didn't press her application for Appendix 4, and she was right not to do so, because that would have been early disclosure. That would effectively require us to do 2 standard disclosure exercises. So paragraph 12 can go. Paragraph 13 as is, and 14. Your Lordship made a ruling on that. And those
13 is 16th September.
I think we moved it to the 23rd to accommodate.
Oh, sorry, 23rd. Quite right. Yeah, 23rd. Yeah.
and on
We
paragraph 40.
haven't got in the earlier CMC of the 17th of July, have we?
No, we haven't yet.
So the 2 CMCs, 17th July and 23rd September. Yeah. 14 is as is if Appendix 3 does what I think it does.
Yes, it is. Yes, that's right. I think my learned friend said that on the CMIS, sorry, the MIS report.
Oh yes, it would take more time.
She wanted longer, and maybe my lord would just have a carve out for that. Would just say save in relation to the MIS reports, a timetable for which is to be agreed between the parties.
Yeah.
The date range for the MIS reports needs to be limited.
Yes.
Yeah.
Vis-a-vis their prior proposal as well.
Yeah.
That can be for the period 2012 onwards.
Yeah.
So I think paragraph 15 can be deleted because that you've made the order separately. And then on paragraph 16, the standard disclosure, I think that's just been agreed.
We've already ordered that.
We've already ordered that, exactly. So we've deleted that, actually. I think the parties had agreed at this point that it would just simply say each of the parties shall provide disclosure in accordance with paragraph 11 of the April order by 4 p.m. on the 8th of November.
Yeah.
And then my learned friends 17 and 18 go, are deleted. And then we're into witness statements, and 21, essentially all the wording in red can be deleted. So that's 21 to 29. And then into expert reports, and the item in red is deleted, but of course there's a liberty to apply. And I'll just make sure that ends up at the end of the order.
I'm sorry, can you say that again, Mr. Shivji? I missed.
Yes, of course. So we're deleting the additional field of banking mergers and acquisitions, but at the end of the order will have a general liberty to apply, which will include a liberty to apply on that point.
Well, maybe I missed where we came down to on responsive witness statements. I thought that.
I think we argued it, and I don't think the court ordered it.
I recall the court saying that sometimes he finds them
I-
useful as
I-
long as they're short.
What I said was there should be liberty to apply to put in any supplementary short supplementary witness statements. What I had in mind was that you might want to do that, Miss Martin, having seen a whole lot of Civil Evidence Act notices, relying on documents that your particular witnesses hadn't dealt with in their statements, but felt they needed to, and by way of a further further short witness statement. But I'm not encouraging anybody, but it's there in case you need it. Liberty to apply in those circumstances.
Yeah, my lord, are you content for that just to be a general liberty to apply at the end of the order?
No, I think I'd like it expressed at this point for that
Right.
liberty to apply to adduce supplementary witness statements in the light of the statements already served by the other side. So that both sides will have liberty, but what I have particularly in mind is the defendants may want to do so. Experts' reports, we're now into the question of experts meeting.
Yes.
Identifying the documents they need to see and discussing methodology. We didn't provide for dates, did we, on that? I don't think.
No, we didn't. But I mean, to my part, I think that needs to happen at least 2 months before the reports, because they need to know, agree
absolutely.
the methodology first. So
Absolutely.
that could happen on. We could say that by
You might make it just after the witness statements, just in case there's anything of relevance in them. I shouldn't think there's likely to be, but there might.
So, but we could say perhaps by the 14th of March. That's the week after.
Yeah.
No, my lord, you did anticipate that the parties would exchange exchange the identity of potential witnesses and potential experts.
I did, yes.
We didn't
quite right.
We didn't discuss when that would happen.
Well, I think I'd envisaged a month or two before the witness statements to identify who it was, in case that meant that the other side thought they ought to dash around and find somebody else. But so sometime in early January. Identification of witnesses sometime in mid-January.
Yes. So why don't we say by something like by the 17th of January 2025?
Yeah.
The parties shall give a provisional indication as to the identity of their factual witnesses and any expert witnesses that they may call.
Yeah.
So, my lord, I think that takes us through to the end, and then just on the costs, your lordship has ordered costs. So it's the wording in green, and then your lordship has said 175,000 dirham.
Yeah.
And my learned friend often says 14 days for payment, so I'm assuming she'd prefer that, in which case that'd be the 24th of June.
I'm sorry, was the number 170 or 175?
Oh, I'm so sorry. I'm correct. It's 170. Apologies, that's my mistake.
14 days would be appreciated.
Yeah, no, that's fine. Sorry, I wasn't trying to bump it up by 5,000 dirhams. That was my mistake.
Could I just make a request that Holman send through confirmation for the payment instructions timely? We generally have to chase them for it rather than the other way around.
I'll relay that to our side. Thank you.
Thank you.
And then finally, we might as well just have something on permission to appeal, so that the court can declare that the appeal notice is filed out of time, and the application for an extension of time is refused.
Yeah.
And then the application for permission to appeal that decision is refused.
Yeah.
I don't know if Miss Martin has anything else, but that's everything on my side. I'm grateful, my lord, for you taking the time to do that. I think it has been a valuable exercise.
Well, that hopefully avoids further dispute.
We appreciate it.
All right. Very good. Thank you very much. If you'd like to sign out, I'll have a quick word with the associate. And I will see you sometime in July by the looks of it.
Thank you, Your Honor.
Thank you.